respect to the third issue, my co-counsel will be making submissions. Much obliged, Your Lordships. If I have the permission, I will succinctly place the facts of the case before Your Lordships. Much obliged, Your Lordships. Your Lordships, the appellant is Deriflux Biogenics INC. It's a multinational corporation operating in various sectors, including pharmaceuticals and healthcare innovation, and is headquartered at Nodovia, a nation known for its high industrial and technological progress and also for its robust business history. In the year 2020, the Zarnovian Ministry of Information Research enters into a public-private partnership with the appellant company in order to explore plant-based compounds to treat neurodegenerative diseases. This collaboration is formalized under an accord called the NeuroHub Discovery Accord. Under this accord, access is granted to the appellant company to the Vila Rainforest Reserve, and in particular to the genetics of a particular endemic species of plant called the Azula plant, which was believed to have some kind of cognitive enhancing properties. And also to the traditional knowledge associated thereto, which was possessed by an indigenous community called Kavanzi community. And this collaboration is hailed as a model for international scientific cooperation. Fast forward to 2025, Mr. Kezaitur, CA and a former financial officer of the Zarnovian Biodiversity Authority, leaks certain documents that allege corruption and regulatory violations, including non-consultation with the tribal community and lack of exclusion of them from access and benefit sharing agreement. Pursuant to this revelation, the Zarnovian Anti-Corruption Bureau registers an FIR against several officials in the appellant company, and the case is under trial before a special court where we have denied any wrongdoing on our part. And Advocate Zara filed a petition before the Biodiversity Tribunal representing the Kavanzi community, accusing us of unlawful access and over-exploitation of the Azula plant. We contended that we had complied with all regulations, and the Ministry of Zarnovia, along with the Zarnovian Biodiversity Authority, contended that the access granted to them, to the appellant company, was a legitimate step towards national scientific advancement. However, the tribunal held the biogenics liable for biopiracy and issued a set of directions only against us, including permanent revocation of our access to the Villa Reserve, seizure of all samples, implementation of a restoration package, and compensation to the community. Aggrieved by this order, the appellants have come before your lordships under section 22 of the NGT Act. Having placed the facts, I now seek to proceed with issue 1. Much obliged, your lordships. Our respectful submission with respect to issue 1 is the appeal filed by us under section 22 of the NGT Act is maintainable because it contains certain substantial question of law as required under section 22. Furthermore, the order of the tribunal fails to adhere to the principles of natural justice and also affects public health and derails scientific progress. Your lordships, having got the statutory right to appeal to this honorable court under section 22 of the NGT Act, for me to maintain an appeal under section 22, I need to meet one or more of the grounds of second appeal specified under section 100 of the CPC. One of the grounds specified thereunder, under subsection 1, is a substantial question of law. Our submission is that our appeal contains certain substantial questions of law. Though the term substantial question of law is nowhere defined, based on the interpretation and the judicial pronouncements of this honorable court, it can be concluded that it is a question which adversely affects substantial rights of the parties. In order to back this, your lordships, I would like to draw the bench's attention to a couple of precedents. Most importantly, to the observations of this honorable court in Chunilal v. Mehta versus and Sons Limited versus Century SPG and Manufacturing Co. Limited. Yes, your lordships. Your lordships, it was held in this court that a substantial question of law is one which adversely affects the substantial rights of the parties, or one which is connected with a matter of public importance, or one which is free from difficulty, or one which is an open question, or one which calls for an alternative view. Our submission is that our appeal contains questions of such character and magnitude.
We are dealing with the substantial question of law.
Yes, your lordships.
So we need not give more importance to the facts.
Indeed, your lordships.
Then what are the substantial questions of law?
Your lordships, there are two substantial questions of law. One is with respect to this tribunal's order seizing all the biological samples that we had collected. The question here is, we proceeded with collecting the genetics of the Azula plant only pursuant to receiving approval in accordance with Rule 14 and Rule 20 of the Biodiversity Rules 2004 and as required under Section 3. So under Section 3, I being a foreign company have to seek the prior approval of the National Biodiversity Authority.
Have you raised this point before the first appellate court?
Your Lordships, at the first instance, this case was before the NGT, and we did raise the contention that we had complied, and that was only supported by the contention of the government as well as the Zarnovian Biodiversity Authority, as indicated in para 13 of the proposition, that they had given us access. So, under
whether the tribunal was declined to entertain on this aspect is concerned?
Your Lordships, we did not contend about the jurisdiction of the tribunal, because the tribunal has jurisdiction.
And how?
Your
Because that is one of the points to be considered.
Your Lordships, we did not contend on the jurisdiction of the National Green Tribunal because
Whether jurisdiction which has not been heard before the first appellate court can be considered in the second appeal?
Your Lordships, we have no contentions against the competence of the tribunal. We are contesting against the determination of the tribunal, but not the competence of the tribunal.
Elaborate.
Your Lordships, NGT being established under the NGT Act 2010 has got jurisdiction over all substantial questions of law relating to environment in respect to the implementation of all the acts
Under which provision?
Section 14 of the NGT Tribunal, Your Lordships.
Yes.
NGT Act.
Go to 40.
Yes, Your Lordships. Just a minute, Your Lordships. Apologies for the delay. Yes, Your Lordships.
Yes, read 40.
Sure, Your Lordships. The tribunal shall have the jurisdiction over all civil cases where a substantial question...
Just you read. The tribunal shall have the jurisdiction over all civil cases.
Yes, Your Lordships.
Stop there.
Yes.
Then, where a substantial question of law relating to environment.
Yes, Your Lordship.
Whether in the facts of the case, whether any substantial question of law is required to be considered.
Your Lordships, if you could repeat it, I would be grateful.
So the tribunal to settle the dispute. This is the marginal note insofar as the 14 is concerned.
Yes, Your Lordships.
The provision reads as that the tribunal shall have a jurisdiction
Yes, Your
over
Lordship.
all civil cases.
Yes, Your Lordships.
All civil cases, no penal action.
Yes, Your Lordships.
Where, that is, what is the prerequisite for invoking 14?
Yes, Your Lordships.
Where a substantial question relating to environment is to be considered.
Yes, Your Lordship.
Now, what is according to you is a substantial question of required to be considered insofar based on the environment is concerned?
Your Lordships, as far as the substantial question raised before the tribunal is concerned, it was not we who approached the tribunal, it was the respondents herein who approached. And we only submitted ourselves to the jurisdiction of the tribunal. And therefore,
now you challenge the order passed by the...
Yes, Your Lordships.
Then what was the substantial question now considered by us based on the already adjudicated matter?
Yes, Your Lordships. The substantial questions for this bench to consider in this present appeal is that...
Because question of law is
Yes, Your
different
Lordships.
from question of substantial question.
Indeed, Your Lordships. Your Lordships, when the law is clear in this aspect,
What is
that
the difference between question of law and substantial question of law?
question of fact is...
Question of law.
Question of law is about the interpretation and the applicable aspect of law. Whereas the question of fact is about the...
Not fact. Substantial question of law.
Substantial law is one which is not clearly determined by any
What's the
pronouncements.
difference?
Your Lordships, a
Any
question...
Any precedent?
Your Lordship, I have Chunilal V. Mehta, as I cited. It says that when it directly or indirectly affects my rights, either the appellant's rights is being affected.
That is question of law.
Yes, Your Lordships.
What is substantial question?
Your Lordships, in this case, it was held that for a question to qualify as a substantial question of law, it should meet either one or any of the criteria which was established. And those include 5. One is it is affecting my substantial rights. It is of a general public importance. The collaborative... Yes, Your Lordships. Your Lordships, coming to the point of general public
Question
importance...
of law is only insofar as controversy between the parties.
Indeed, Your Lordships.
Substantial question of law, in the event if any adjudication is made, that will affect the public at large.
Sure, Your
That's
Lordships.
the difference.
Your Lordships, here the public importance is this collaboration was taken up between the ministry and us only to come up with a drug, a plant-based drug, to treat neurodegenerative diseases which is prevalent in the world today. And as a matter of fact, neurodegenerative diseases presently do not have any remedy which works with 100% efficacy. Therefore, believing that the Azula plant had cognitive enhancing properties, the ministry initiated a collaboration with us because we are good at technology and we come from a very technologically advanced country to work together. And it is in this for this purpose that this collaboration was taken up. And now, as I said, Your Lordships, I proceeded as I submitted, Your Lordships, I stand corrected. As I submitted, Your Lordships, indeed, Your Lordships, I stand corrected. Grateful. As I submitted, I have collected the samples of a particular endemic species of plant upon complying with Rule 14, 20 and Section 3 of the BD Act. And the ministry as well as the ZBA contended before the authority, before the NGT, that they had given us access. So I have collected all the samples legally. And also one of the allegations that they cast as a lighter note, I want to mention that, is that the community was not consulted. Without consultation of the community, I could have not got the access at all. And even that would have been raised as an objection by the ZBA and the Zarnovian ministry. Therefore, and also, Your Lordships, this being an endemic plant, only found in that particular region, and this being a traditional knowledge which has been always within the tradition, within the knowledge of the members of the community, I couldn't have even figured out which plant is an Azula plant without their cooperation. Therefore, despite all such compliances and due regards to all the rules, the tribunal has ordered for seizure. And now what does it do? The impact on public health. It halts a scientific progress, which was scientific research, which was taken for a noble cause. And not just that, by ordering a seizure, it undoes all the scientific progress that we had made so far. And Your Lordships, the collaboration and the due process granted, due access, apologies, Your Lordships, due access granted to us by the appropriate authority here in the ZBA was in line with the preamble of the Convention on Biological Diversity, page 44 of the compendium. One of the objectives of the Convention on Biological Diversity, which India has acceded and as well as ratified, is that sustainable use of biological diversity is critical for meeting the health needs for which purpose access to and sharing of genetic resources and technologies are essential. And not just that, Your Lordships, this collaboration is also in line with Article 8 Clause B of the Nagoya Protocol, page number 79 of the compendium, which states, with due regard to cases of present or imminent emergencies, parties may take into consideration the need for expeditious access to genetic resources and fair and equitable sharing of benefits. And Your Lordships, the blanket revocation and the blanket order of seizure of samples that we had collected in due compliance is also incongruous with Article 15 Clause 2 of the Convention on Biological Diversity, page number 53 of the compendium, which says that each contracting party shall endeavor to create conditions to facilitate access to genetic resources. And Your Lordships, this was all done under and as per the NeuroHub Discovery Accord 2020, which was signed by both the parties. And the accord was well within the legal frameworks, both international and domestic. And now, whatever we have done has been in consonance with the accord, which has stood the test of legality, and which remains unchallenged. Therefore, in light of these facts, ordering of seizure impacts, cripples international cooperation and also casts an adverse impact on scientific progress and also public health. Your Lordships, and as far as the inadvertent consequences that the project is resulted in a particular area of the Rainforest Villa Reserve, we undertake the responsibility, as we should under Rule 12, and also under the principle of polluters pay principle, which is premised on principle of absolute liability. Therefore, we are not in any way escaping from our responsibility to decontaminate or restore. But our pleading herein is that it should be in conjunction with the government.
Is the case that the proposition relating to polluter pays?
The part of the proposition which deals with...
In which case the Supreme Court is pointing out that?
Your Lordships, one of the cases in which the Supreme Court is, the NGT and also the Supreme Court is...
Honorable Supreme Court.
The Honorable Supreme Court, apologies Your Lordship, the Honorable Supreme Court is relied is Vellore District case, the tanneries one. Yes, Your Lordships. So, therefore, this I would not see as a liability. We have been held liable only for biopiracy, which my co-counsel would deal under issue 3, Your Lordships. And the rest of the directions are in accordance with the polluter pays principle, to which we bow down, as we should. But the nuance or the overlooked fact here happens to be the collaborative character of the project. The collaborative character of the project has been completely overlooked. Therefore, our submission to the Honorable Bench is that we are readily willing to undertake the task of decontamination. We are readily willing to compensate the community and implement a restoration package, but it should be in conjunction with the government.
Whereas such a provision was there before that you were signing the agreement?
Your Lordship, we signed this agreement in 2020, therefore such provisions were already in existence.
Something is not there in the contract.
Your Lordships.
How can you read all these things into the contract?
Your Lordships, we have not been provided with all the details of the accord. And this was in 2025. By then already there was 2010 Act of NGT. And Section 20 of the NGT Act does say that it should apply the principles of sustainable development, precautionary principle, and polluter pays principle, to which we bow down.
What's the difference between the polluter pay as well as the substantial development is concerned?
Your Lordship, a polluter pays principle is premised on the rule of absolute liability in order to ensure that the big industrial...
in which case the Honorable Supreme Court enunciated?
Your Lordships, I'm not completely confident on which particular case of MC Mehta, but I can assure that it was one of the cases filed by Mr. MC Mehta.
MC Mehta or 88 MC Mehta?
Your Lordships,
4 MC Mehta.
I plead ignorance of providing that clarity, Your Lordships, but I'm quite sure that it was MC Mehta's case. So therefore, we have no other option but to bow down to it. And also, Your Lordships, one of the facts which I would like to present to Your Lordships is throughout the proposition, all the 15 paras, nowhere as the government nor the Zarnovian Biodiversity Authority contended that we have breached any terms of the accord. Therefore, yes, Your Lordships.
On the one hand, you admit that you have violated environmental dignity enforcement. On what basis you have violated?
Your Lordships.
Having admitted that you have violated the environment.
Your Lordships, I humbly beg to differ in this aspect with Your Lordships. We are not admitting the liability. We are only owning up the responsibility. And Your Lordships...
You have admitted the violation of degradation of that particular lake.
Your Lordships, I would like to repeat myself, but the thing is, Your Lordships, first there was an accord formalized, and that accord has not been challenged. It has stood the test. And under the accord, I and the partner, which is the Zarnovian Ministry, had certain obligations. And it is in pursuance of those obligations that we have conducted ourselves. Therefore, the legality of my action seems to be established, Your Lordship, with all humility. Now, whatever inadvertent occurrence has occurred around the particular place where we have been operating, we are owning up the responsibility for that, Your Lordships.
You are admitting that you are going to restore the lake.
Yes, Your Lordships, I am obligated to do that.
Basically, you have violated.
Your Lordships, again, with due respect, Your Lordships, because it is absolute, it is principle of absolute liability, regardless of my...
We will allow you repeat.
Your Lordships, grateful. Your Lordships, one, I would pray before Your Lordships to lift the seizure on biological political samples because it had been collected in due compliance, and second, to enjoin the responsibility of compensation and implementing a restoration package with the government as well. Therefore, Your Lordships, we are behaving very responsibly. We are not escaping or evading any of our responsibility on our part, Your Lordships. Your Lordships, if Your Lordships are convinced on first issue, I would like to make a summary submission and then proceed with issue 2. Your Lordship, I most respectfully submit that the...
What is the substantial question of law in order to maintain this?
Your Lordships, one, when there is a due compliance and yet there is a seizure,
That's not the substantial.
Your Lordships, that is ultimately resulting in denial of the right to public health, because the consequence of this collaboration would certainly at one point result in a drug which would effectively treat neurodegenerative diseases. And therefore, and even the state, as a matter of fact, has an obligation, a positive obligation towards promoting public health. So therefore, it is something very noble that we have taken up, which would treat neurodegenerative diseases, hopefully, Your Lordships. Your Lordships, the appeal is maintainable under Section 22. It raises questions that have great bearing on the rights of the appellant, on public health and scientific advancements. The tribunal's order overlooks facts, does not impose the responsibility evenly, and causes crippling effect on international cooperation. Your Lordships, now I seek the bench's permission to proceed with issue 2. As far as the issue 2 is concerned, my most respectful submission is that none of the fundamental rights of the Kavanzi community have been violated. Your Lordships, para 8 of the proposition states that over 250 families had been displaced in order to facilitate the implementation of the project. This displacement was not carried by the company, as we are not allowed to do it. We do not have any position to do it. This was undertaken by the state under its authorization, and this stands justified on the doctrine of eminent domain, which is premised on the principle that the welfare of the people is paramount. Your Lordships, Your Lordships, Your Lordships, Your Lordships, I am not the state, but the allegations of violation of fundamental rights have been leveled against me as well. Exactly, Your Lordships, I completely agree. That's also my point of submission, that I do agree with this. Yes, Your Lordships, I'm obliged to do it. Therefore, the state, Your Lordships, I am not claiming any action on eminent domain. It is the state which has done, Your Lordships. Yes, Your Lordships. Yes, Your Lordships. Yes, Your Lord. Yes, Your Lordships. Your Lordship, my sub. Your Lordships, I was not prompted by the state. I was prompted by the aggrieving order of the tribunal, which is ordered for seizure of all the samples that we had worked on so far. Your Lordships, if I may, my appeal to this honorable court. Yes, Your Lordships. Your Lordships, I humbly beg to differ. I have come on appeal. I humbly beg to differ, Your Lordships. Your Lordships, my appeal has been strictly confined to the order of the tribunal, which has been in respect of the responsibility of restoration, compensation, and seizure. I have come strictly under Section 22. But the Honorable Supreme Court, having had a lot of petitions related to these matters, has clubbed and thereafter framed questions of constitutional implication, as para 15 of the proposition states. The last 2 or 3 lines of the proposition, Your Lordships. Your Lordship, it is the Honorable Supreme Court. Your Lordships, considering, okay, Your Lordships, 15. Your Lordships, yes, Your Lordships. Aggrieved by the tribunal's ruling, Geniflux Biogenics Inc. filed an appeal before the Supreme Court of Zarnovia. Yes, Your Lordships. In its memorandum of appeal, yes, Your Lord, that the tribunal had violated principles of natural justice. Yes, Your Lordships. Your Lordships, my submission with respect to the questions of constitutional implication is with respect to issue 2. Neither there was any contention by the petitioner nor had we brought up the issue of fundamental rights before the NGT. Upon admission of, upon our appeal and also of the appeals of and petitions of other parties, the Honorable Supreme Court has clubbed and then framed questions. Your Lordships, next page, Your Lordships. Your Lordship, the last 2 lines of the, considering the broad legal and constitutional implications, the Supreme Court clubbed all related proceedings for a final hearing, Your Lordships. Grateful, Your Lordships. Your Lordships, there is a judgment of this Honorable Court. Your Lordships, the mentioning of Section 100 in Section 22 is only for me to maintain my appeal under Section 22. Section 22 confers the jurisdiction to the Supreme Court, and for me to maintain an appeal, I need to meet one or more of the grounds of Section 100. Therefore, the mentioning of Section 100 is for a very limited purpose as to permit me on which grounds I can maintain an appeal, Your Lordships. Much obliged, Your Lordships. Your Lordships, I would, and this principle of, yes, Your Lordships. The doctrine of eminent domain is statutorily recognized under the Land Acquisition Act of 2013, Your Lordships. Section 2, subsection 1 of the Land Acquisition Act of 2013 empowers the central government to acquire any land either for its own use or to hold, control, or for PS use or for public purposes. And also the Act enumerates a list of public purposes, and point number 6 under clause B, subsection 1 to section 2, page number 266 of the compendium, Your Lordships, is projects for healthcare. And Your Lordships, clause A to subsection 2 of section 2 specifically provides for acquisition of land for public-private partnership entered into for any public purposes enumerated under subsection 1, which includes healthcare. And Your Lordships, and as required under section 2, subsection 2, the ownership still rests with the government. The ownership has not been transferred to us, Your Lordships. And before I conclude, Your Lordships, I would like to draw the attention of the Honorable Court to 2 judgments of this Honorable Court. One was in Narmada Bachao Andolan versus Union of India, wherein it was specific about the tribal community. And the learned Lordships of that, adjudicating that matter, held that in para 62 of page number 252 of the compendium, that the displacement of the tribals, apologies, Your Lordships, and others would not per se result in violation of their rights. The effect is to see that on their rehabilitation at new locations, they are better off than what they were. And Your Lordships, the observations of this Honorable Apex Court in Chameli Singh and others versus State of UP. Yes, Your Lordships.
I remember it, I also read it.
Yes, Your Lordships.
There, insofar as there is no interstate state contentions. That is arising out of from High Court of Gujarat, if I remember it.
Indeed, Your Lordships.
That is appeal. Here, the controversy between 2 states.
Your Lordships, if I may beg to differ, there is no controversy between 2 states as such. It is strictly between the Geniflux and the Kavanzi community and also the government. There seems, in my humble opinion, that...
There was some political controversy between 2 states.
Your Lordships, that is in relation to some international relations. Yes, there is a mention of in the proposition.
Yes.
Yes, Your Lordships. 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 Yes, Your Lordships.
For not making adequate facilities. That is what the contention is. In Narmada Bachao Andolan case, they have been provided with better facilities.
Your Lordships. Yes, Your Lordships. First, I would like to reiterate that this project qualifies as a public purpose project under Section 2. Your Lordships, I beg for an additional grant of 2 or 3 minutes to conclude. This project qualifies as a public purpose project under Section 2. Under Section 2 of the Land Acquisition Act, number 1. And the displacement has been in accordance with that act, number 2. Number 3, Your Lordships, there has been no plea even before the NGT that...
Need not be, because don't you think it affects the rights of the tribe?
Your Lordships...
Tribe community under Article 8, 11, 21 and 31 of the 29 and 31 of the Constitution.
Your Lordships, the Land Acquisition Act, which has stood the test of constitutionality, it has been done in pursuance of that. And when there is a conflict between private interest and public interest, interest must be given primacy, Your Lordships. And moreover, displacement has been done, Your Lordships, in accordance with the statute. And Your Lordships, here, and I would like to again reiterate that it's between the Geniflux Biogenics and the Kavanzi community, Your Lordships. And to summarize my respectful submission to this honorable bench, relocation of a certain number of families or tribe happened under the authorization of the state to facilitate the implementation of the accord, and acquisition of a small portion of land was done strictly according to the Land Acquisition Act, and the ownership of the acquired land rests with the government itself. Your Lordships, if your Lordships are convinced, my co-counsel will continue third issue.
Your Lordship, Council seeks permission to address the bench collectively as Your Lordships. Much obliged, Your Lordship. Unless the court had any preliminary questions to begin with, Council seeks permission to proceed with issue number 3.
You're expecting?
Indeed not, Your Lordship. Much obliged, Your Lordship. Issue 3 reads as whether Geneflux Biogenics Incorporation has acted in violation of domestic or international biodiversity frameworks. Your Lordship, it is most humbly submitted by the appellant, that is Geneflux Biogenics Incorporation, in the instant case has not violated domestic as well as international biodiversity frameworks, Your Lordship. I would like to further substantiate my arguments in 5-fold manner, Your Lordship. Moving forward with the first fold of my argument, that is, we have complied with the Biological Diversity Act of 2002, Your Lordship. Your Lordship, the Zarnovian Biodiversity Act of 2003 is in paramateria with the present India's Biological Diversity Act of 2002, wherein the statutory definition of the term axis has been given under Section 2, Clause A of the same Act, Your Lordship. For Your Lordship's perusal, it is mentioned in page number 320 of the compendium. Your Lordship, the term axis has been defined as collecting, procuring, or possessing any biological resource or traditional knowledge for the purpose of research or commercial utilization, Your Lordship. In the instant case, Your Lordship, there is a clear distinction between lawful access with permission and unlawful exploitation of biological resources, Your Lordship. In the instant case, appellant, that is Biogenics Incorporation, has conducted research-based project wherein we were trying to find a plant-based compound for treating neurodegenerative disease, Your Lordship. Moving forward with the term research that has been defined under Section 2 Clause M of the Act, for Your Lordship's perusal, it is mentioned in 322 of the compendium, Your Lordship. The term research has been defined as study or systematic investigation of any biological resource for any use, Your Lordship. In the instant case, Your Lordship, the appellant's project that has been granted access under the Neuro-Herb Discovery Accord of 2020, which is mentioned in para 4 of the Moot proposition, it is clearly research-oriented, Your Lordship. What we are trying to do here is doing biosampling, biosurvey, data collection, data analysis of such genetic resource of the plant azul, Your Lordship, for which we have taken the consent from the Zarnovian Ministry of Innovation and Research, Your Lordship. And moreover, Your Lordship, this is not an commercial activity that has taken place, but rather a systematic research and the systematic scientific investigation that has taken place, Your Lordship. Moreover, the term commercial utilization has also been defined under the same Act, which is mentioned under Section 2 Clause F. Your Lordship, it entails that end use of biological resource for commercial utilization such as drugs. Your Lordship, it simply refers to extraction of a biological resource and converting that into a marketable product that could be sold. For example, drugs, enzyme, fragrances, etc. Your Lordship. But in the instant case, Your Lordship, we are still at the preliminary investigation stage wherein we are understanding and recognizing the nature and the properties of the plant Azula, Your Lordship. And moreover, all of this does not entail.
So you're not, it's for foresee what will happen in the future. But already you entered into a contract.
Your Lordship, Your Lordship,
Before entering the contract itself, that you must have some material. No?
Your Lordship, under Your Lordship, under para 4 of the Moot proposition, it has been clearly stated that Geneflux Incorporation has entered into a public-private partnership, that is PPP, with the Zarnovian Ministry of Innovation and Research for the grant of access of the plant Azula, Your Lordship. And this was primarily known for its medicinal properties for treating neurodegenerative diseases, Your Lordship, and hence we have accessed this plant. Your Lordship, under Section 3 of the same Act, it states that any foreign company or a person who is accessing the biological resource of India, they must take the prior informed consent of the National Biodiversity Authority, NBA, which is in para materia with the Zarnovian Biodiversity Authority, ZBA, Your Lordship. In the instant case, we have taken the consent from the Zarnovian Biodiversity Authority, Your Lordship, and hence there is no exploitative use of this plant Azula, Your Lordship. Moving forward with the second fold of my argument, Your Lordship, that is, we have complied with the Convention on Biological Diversity of 1992, as well as the Nagoya Protocol and Access and Benefit Sharing of 2010, Your Lordship. Your Lordship's perusal in page number 53 and 54 of the compendium, Your Lordship, Article 15 of the CBD of 1992 has been given, Your Lordship, wherein it recognizes the sovereign rights of the state over its own natural resources, Your Lordship, and moreover, access to the biological resources shall always be subjected to the prior informed consent as well as mutually agreed terms of the contracting parties, Your Lordship. In the instant case, the contracting parties refers to the Zarnovian Ministry of Innovation and Research as well as the Geneflux Incorporation. Indeed not, Your Lordship. The Kavanzi...
What do you say about the United Nations Declaration on Rights of Indigenous Peoples, Article 11, 29 and 31, which guarantees indigenous people's right to remain, control and protect their cultural heritage and traditional knowledge? What do you say?
Indeed, Your Lordship. Indeed not, Your Lordship. I would like to answer your question by stating that under Article 18 of the UNDRIP of 2007, Your Lordship, the indigenous people also have rights over their decision-making matters which affect their own rights, Your Lordship, and this can be done through their own procedures and representatives.
There is an element of decision-making process, then they have to be heard.
They have to be heard, their consent has to be taken.
Indeed, Your Lordship. To answer your question, Your Lordship, firstly, we are still at the preliminary investigation stage, Your Lordship. Any trigger...
Now raise a point. Post-decisional hearing.
Your
I
Lordship...
have given a hint for you. Post-decisional hearing.
Your Lordship...
You take decision and thereafter hear them.
No, Your Lordship.
No. I have given a hint for you, for argument. This is a final, no, nothing will happen. No problem.
We have...
Post-decisional hearing is there in Maneka case 78 Supreme Court. In rural litigation case insofar as the environment is concerned.
Your
And
Lord-
also insofar Neela Bharti Behra in 93 Supreme Court insofar custodial. So that could be done, you know, here
Your-
also.
Indeed, Your Lordship.
Because they are not the parties insofar as the contract is concerned. But however, ultimately their rights have been affected.
Your Lordship,
Then they have to be heard.
Your Lordship, to answer your question, firstly, we have consulted the Kavanzi tribal community, Your Lordship, and this has also been mentioned in the Moot proposition, Your Lordship. Indirectly, they were consulted, Your Lordship. Without their cooperation and without the legal channels through which we have accessed the Azula plant, it would have been impossible without the Kavanzi tribal community's cooperation, Your Lordship. As I mentioned, under Article 18, Your Lordship, firstly, Your Lordship, any trigger point for access and benefit sharing agreement would be commercialization. As I stated earlier, the definition of the term commercialization, Your Lordship, which simply means the extraction of biological resources that I've done. I am converting that into a marketable product and selling that in a market where people can consume it. For example, drugs, enzymes, fragrances. But in the instant case, we are only at the preliminary investigation, that is the...
Have you been stating that you are in the preliminary investigation
Not
stage?
correct.
Then under what circumstances you are going to apply for patent of that particular product? Even if it is developed only, then you will apply for patent, no?
Indeed not, Your Lordship. To answer your question, firstly, before filing of patent Your Lordship, we can file patent before we've developed a product, Your Lordship, because Your Lordship, the main purpose and the aim of filing for patent registration is simply because we don't want others to copy that similar product. And Your Lordship, in the instant case,
Product, yes. Product, yes. Still you have not developed the product.
No, there is no product at all.
indeed, Your Lordship, and also Your Lordship, patent registration rights have not been granted to us yet. It is still pending, and
No,
it is
that patent insofar as the similar process cannot be done any other, but not the end product.
indeed, Your Lordship. My apologies.
Process is different from end product.
Indeed, Your Lordship. My apologies for that. Your Lordship, under the Nagoya Protocol as well, they've mentioned under Article 6 and 7 of the Nagoya Protocol of Access and Benefit Sharing, page number 78 of the compendium, Your Lordship. Even there, they've mentioned that there must be prior and informed consent and mutually agreed terms, Your Lordship, from the provider country. Your Lordship, in the instant case, the Zarnovian Ministry itself has given us the permission to access the Azula plant, Your Lordship. And moreover, Your Lordship, I would like to move... Your Lordship, I would like to now move forward with establishing the fact that GeneFlux has acted under the NeuroHub Discovery Accord of 2020.
Not in dispute that there is a contract between dignitaries and that particular product. It is not in dispute.
Indeed, Your Lordship.
Having taken that permission, you have highlighted the terms of the contract is the question which put in.
Indeed not, Your Lordship. Indeed not. We have consulted and we have taken the consent from the Kavanzi tribal community, Your Lordship.
Where is that argument?
Your Lordship, also... Just a minute, Your Lordship. Even in the Moot proposition, it has been held in para 15, Your Lordship. They've held that GeneFlux claimed that the Kavanzi community had been indirectly represented during... Indeed, Your Lordship. Your Lordship, I would just like, as my learned counsel also mentioned that, for example, just let's assume that we have not got the consent from the Kavanzi tribal community. When I visit the Villa rainforest, it would be impossible for me to identify which plant in itself is Azula, Your Lordship, because the Kavanzi tribal community has this particular knowledge, and without their consent, we couldn't even have entered the Villa rainforest, Your Lordship. And thus, I would like to answer your question, Your Lordship. I would like to move forward with my further submission. Your Lordship, firstly, let me finish that, as I was stating earlier, the third fold of my argument, that is, GeneFlux has acted in good faith under the NeuroHub Discovery Accord of 2020. Your Lordship, neurodegenerative disease is a type of disease which is progressive in nature, and it affects the central nervous system of a human body, Your Lordship. It mainly impairs the memory, cognitive abilities, and the ability to movement.
When the question related to human rights, fundamental rights, natural rights of persons, can the doctor of good faith
Your Lordship, the contention that I am trying to make is that under the NeuroHub Discovery Accord,
question relating to the deprivation of the fundamental right or human right or natural rights is concerned, whether the doctrine of good faith will step into this here?
Your Lordship, to answer your question, I would just like to take a
Good faith is law of equity. Human rights, fundamental rights is the constitutional right.
Indeed, Your Lordship.
Then good faith will not come.
Your Lordship, as my learned counsel has already argued that there has been no violation of the fundamental rights of the Kavanzi tribal community, Your Lordship, the main purpose and aim of starting this project in itself was that we understood that there is a traditional that there is a plant called as azula, which has traditional medicinal properties and has healing.
No, it was very simple. Before entering a contract with other person, you should have consulted them.
We have consulted with them, Your Lordship.
That's all. If you have consulted, then taken their concurrence or consent, that would have been the basis insofar as they protecting their interest also.
Your Lordship, to answer your question, we have taken the consent from the Kavansi tribal community, Your Lordship. The last fold of my argument was that, Your Lordship, the Zanovian Ministry of Innovation and Research, the Zanovian government in general, they have misrepresented the Kavansi tribal community, Your Lordship. They have misrepresented them and has breached their own statutory duties, Your Lordship, because they have done...
But they are not the parties here. No?
Your Lordship, they are the parties in our instant appeal, Your Lordship.
They are also parties.
Indeed, Your Lordship. Your Lordship, there has been an...
Who represented tribal area?
Your Lordship, under our appeal, we have mentioned the respondents to be...
So both of you are arguing without the person who will be aggrieved.
Indeed not, Your Lordship. Your Lordship, the state has an obligation to represent, Your Lordship, and hence we have, under the respondents, there is the Kavansi tribal community as well as the Zanovian government, Your Lordship. Coming to the Zanovian ministry, Your Lordship, they have misrepresented and created an illusion of consent that they have taken from the Kavansi tribal community, Your Lordship.
Have you initiated anything other?
Indeed, Your Lordship. Your Lordship, the contention that I was trying to make is that the the Zanovian ministry has given a misrepresentation on the part of Zanovian ministry has given a misrepresentation on the part of Kavansi tribal community, Lordship, and hence we were under the impression that they had given us consent. Yes. My humble.
Say if you use the word misrepresentation, then section 1718 of contract.
Indeed, Your Lordship.
That's it. It's a miscarriage,
Yes.
not misrepresentation.
Indeed, Your Lordship. My apologies. Your
Legal
Lordship.
language is different from
Your Lordship. My apologies, Your Lordship.
You say misrepresentation. In our mind, we go to the contract act, section 1718.
Indeed, Your Lordship.
We have been misguided.
My apologies, Your Lordship. Your Lordship, under Article 18 of the Convention on Biological Diversity Act of the Biological Diversity of 1992, under page 55 and 56, Your Lordship, in the compendium, Your Lordship, here it has been clearly stated that parties must promote international, technical as well as scientific cooperation, Your Lordship. I would like to draw your attention to para 5 of the Moot proposition, Your Lordship. Here they have clearly stated that the project was initially hailed as a model of international scientific cooperation. Your Lordship, even the Zanovian ministry had considered this to be a international scientific cooperation and a scientific advancement toward in the field of neuropharmaceuticals, Your Lordship. As I stated earlier, the neurodegenerative disease is a type, for example, Alzheimer's, Parkinson's, Huntington's disease. Your Lordship, these types of diseases affect the central nervous system of a body and has no cure till date, Your Lordship. There are only symptomatic treatments that are available. But in the instant case, appellants as Geneflux Incorporation, we are ready and we are accessing this Azula plant only for the purpose of creating a drug which could cure this neurodegenerative disease, Your Lordship. Hence, we have complied with the Neuro-Herbal Discovery Accord, Your Lordship. Also, Your Lordship, I would further like to contend that there has been no biopiracy on our part, Your Lordship. I would like to state out the definition of the term biopiracy, which states that unethical or commercial exploitation of biological materials that are native to a particular country without providing fair compensation to that territory, Your Lordship. Firstly, I would state out the essentials of biopiracy and tell how it has not been violating. First essential of biopiracy is that, Your Lordship, there must be an unauthorized access of biological material. Your Lordship, in the instant case, the Azula plant is an endemic species that is restricted only to the Villa Rain forest. Your Lordship, we have taken the prior consent from the National Biodiversity Authority under Section 3 of the Biological Diversity Act of 2000.
Why
Your Lordship, firstly, the third issue deals that whether we have violated international or domestic biodiversity frameworks. To answer that, Your Lordship, we have not violated the biodiversity frameworks because we have taken the prior consent from the Ministry as well as the Zarnovian Biodiversity Authority, Your Lordship.
Because your co-counsel argued that we are ready to restore the Abdullah Lake.
Indeed, Your Lordship.
Since it has been violated, yes, if it is not been violated, there is a question of restoring it to its possibility.
Indeed, Your Lordship. As far as that is concerned, as my learned counsel already mentioned that as per the polluter pay principle, there is absolute liability on the part of any company for that matter, Your Lordship, and hence,
Basically, you are admitting that you are sorry.
indeed not, Your Lordship. The absolute liability strictly dictates that whether or not you've taken due care or attention. It doesn't even matter, Your Lordship, whether we've taken due care or not. We have to pay. That is what the principle clearly states, Your Lordship. Your Lordship, as I have just a minute, I would like to make this contention. Your Lordship, Your Lordship, we have applied for the patent registration in European Patent Office, Your Lordship, wherein Rule 26 Clause 1 states that the last but second para, Your Lordship. Here it has been clear, Your Lordship, I would just wrap it up quickly. Your Lordship, here it has been mentioned that for inventions based on my apologies, Your Lordship. For
We are no way concerned with it. Your counsel has been paid for that.
my apologies, Your Lordship. Your Lordship, under Rule 26 Clause 1, it states that for inventions based on biological material of plant or animal origin or using such material, it is recommended that the application, where appropriate, include information on the geographical origin of such material. Your Lordship, the last submission that I would like to make is that Your Lordship, in the instant case, we filed for the patent under the European Patent Office, which clearly dictates that it is not mandatory on our part to reveal the biological origin or the traditional knowledge that is associated with it. Your Lordship, I would. Your Lordship. Your Lordship, as far as the third issue is concerned, we have not violated the domestic or international biodiversity. Your Lordship, under the Biological Diversity Act of 2002, we have complied with Section 3 as well as Section 2 Clause A, Section 2 Clause F and Section 2 Clause M of the Act, and in accordance with the Nagoya Protocol of Article Nagoya Protocol of Article 6 and 7, we have complied with it. Coming to the CBD of 1992, we have complied with Article 15 and also Article 18 of the UNDRIP of 2007. Your Lordship, can I, with the due permission of the bench, I would like to move to the prayer.
Yes.
Much obliged, Your Lordship. Therefore, in the lights of facts presented, issues raised, arguments advanced, and authorities cited, the appellant most humbly prays before this honorable court to be pleased and to adjudge and declare that, firstly, the present appeal is maintainable, secondly, to set aside the order of the Biodiversity Tribunal, thirdly, Geneflux Biogenics Incorporation has not violated any fundamental rights of the Kawanzi tribal community, as well as not violated the international as well as the biodiversity framework. Fourthly, to hold the Republic of Zarnovia equally liable and to restore their biodiversity. Much obliged, Your Lordship. It was indeed an honor to argue before this honorable bench.
Making purchase is sufficient. At current degree. Yes.
The Council seeks the Honorable Bench permission to address The Republic of Zernovia and Nardovia. The Republic of Zernovia is a mega diverse country with one of the world's highest concentration of endemic plant species, spans over 3 million square kilometers and lies within the equatorial belt. Zernovia ratified the Convention of Biological Diversity. And the Republic of Nardovia is a highly industrialized and technologically advanced country. It is much obliged, Your Honor.
Now you have seen what are the grounds has been right side.
Indeed, Your Lordship. Much obliged, Your Lordship. My argument will be based on how the order was reasoned under the law and has competent jurisdiction under Section 14 Clause 1 of the National Green Tribunal Act of 2010. The appellant fails to satisfy the test of substantiality of law and the claim of disregarding of legal principles or the violation of natural justice is not maintainable before the court, Your Lordship. And how the fundamental rights by the actions of the gene flux have violated and pushed the tribes, the Kavanzi tribes, into mere animal existence, Your Lordship. To begin with, Your Lordship, the tribunal under Section 14 Clause 1 has competent jurisdiction and mandated by the law under Section 14 of Clause 1, where it decides about the matter relating to environment. And the tribunal, as held under the Article 323A and B, it acts under the duty of Act Judicially, Your Lordship, and discharges all its duty under the Act Judicially, the magazine. Under Section 4, if you look at the composition of the National Green Tribunal Act, the members, we have the judicial members and the expert members, and are included to meet the ever-growing and the evolving times about the to dispense about the ecological matters, Your Lordship. Also, if you look at the qualification which is mandated under the Section 5 of the National Green Tribunal Act, Your Lordship, the environmental jurisprudence is settled on the principle, on the polluter pay principle, and runs on the precautionary principles too. And the absolute liability is also been held in the MC Mehta case, Your Lordship. And the absolute liability which is held in the MC Mehta case, it states that the industries which pollutes or deals with hazardous materials in relation to the industries which is operating, which it has the absolute liability to take the precaution, and if any case of miscarriage occurs, it is absolutely be held liable, which was held in the MC Mehta case, Your Lordship. Referring to the Moot memorial, Your Lordship, the Para 10, which deals about the environmental assessment, reported drastic depletion of azolla plant population due to the over-harvesting. And coming to the Para 4, where the Zernovian Eastern Province, Verdania, is a biodiversity hotspot. I beg your apology, Your Lordship, that is Para 3. Zernovian Eastern Province, Verdania, is a biodiversity hotspot containing the Vela Rainforest Reserve and houses over 45% of biological biodiversity. And coming to the Para 4, the Zernovian Ministry of Innovation Research entered into public-private partnership to discover the pharmaceuticals, to explore the plant-based compounds. Your Lordship, the public-private partnership, which has been which states that the public and the private to collaborate together to form a agreement on the basis of their stated objectives to discharge their contractual obligation. It could be in development or it could be any matters of their such. In coming to the Para 4 of the issue, Your Lordship, in 2020, the Zernovian Ministry of Innovation and Research entered into a PPP model with the gene flux biogenics to discover the plant-based compounds for treating neurodegenerative diseases. This collaboration was formalized under the Neuro-Herb Accord, granting gene flux access to genetic materials and traditional knowledge related to azolla plant, Your Lordship. And the azolla plant is specifically found in the Lake Azul, the only freshwater freshwater lake in Verdania, and it is also designated wetland under the Ramsar Convention. which can be ascertained in the para 3 of the Moot proposition, Your Lordship. On the basis of the absolute liability and the precautionary principles, it has been held that the environment, particularly the gene flux, deals with the pharmaceuticals, Your Lordship, pharmaceuticals, and it has been the neurohub initially was accorded to the status because of the discovery of the neurodegenerative medicines. On such, the environmental assessment reported the drastic depletion, and the azul plant was the population, the plant population over-harvesting due to over-harvesting and chemical exposure has been tested positive for the contaminants. And the tribal healers, the Kavanzi tribe, where they specifically rely on the azul plant for their spiritual and healing purposes, and their right to carry profession and trade to commerce, and including their specifically, which will be dealt in the issue 2, how the lack of alternative remedies which are not available, they have forced their Kavanzi tribe's existence into a mere animal existence, Your Lordship. Yes, Your Lordship. Your Lordship, Your Lordship, Your Lordship, we, the representing the Kavanzi tribe, have filed a petition before the Biodiversity Tribunal about the gene flux axis. So, Lordship. Generally, Your Lordship, which has the developmental label, which will be assumed as something. No, Your Lordship. No, Your Lordship. We were after the environmental assessment being done, the drastic depletion of the plant azul.
Brother would say you have been managed by this.
Your Lordship.
You have been managed by the state not to fight, not to raise this subject.
No, Your Lordship.
If you are directly accused by the concerned or the private, the public partnership, you have raised this thing in the beginning.
Your Lordship, the issue was, actually was after the environmental assessment, and specifically referring to the para 8, the leaked documents of the Kavanzi community, which can be ascertained from the whistleblowing documents. They revealed that the Kavanzi community has not consulted during the approval process of the ABS agreement. Yes, Your Lordship. The consult. Your Lordship. Nagoya Protocol, Your Lordship. Under the Nagoya Protocol, and which also the Convention on Biodiversity. I beg your apology, Your Lordship. Your Lordship, under Section 4 of the Biodiversity Act of 2024, which deals with the prior approval of the Access Benefit Sharing Agreement, Your Lordship. And coming to the appeal doesn't satisfy the statutory provisions. The humble submission before the Honorable Court that the Section 22 also mandates the fulfilling the essentials of under this Section 100 of CPC, which includes the substantial question of law as earlier by our Lord Counsel stated or pleaded. The appellant must satisfy the crucial prerequisites out in the Section 100 of the Code of Civil Procedure, requiring the existence of substantial question of law. Here, the substantial question of law and the question of law is being differentiated, and the only question here arises is the question of law, because it doesn't affect at the large question, Your Lordship, specifically dealing with the appeal matter, not with the dealing with the rights of the Kavanzi tribe, Your Lordship. I beg to differ, Your Lordship. The issue.
Now, who are you representing?
Kavanzi tribe, Your Lordship.
That's fine. That's why
The substantial.
not an Indian case.
This, as earlier.
Representing entire tribal community.
Yes, Your Lordship.
Then it affects entire your community.
the substantial question of law which is here is the about the appellant's appeal maintainability. I am here to repudiate that the appeal doesn't maintain before the honorable court, and in that matter the substantial question doesn't have any the I mean it is further contended that the the honorable court, Supreme Court is not a fact-finding authority. Their claim is, which is which merely claim the violation of their substantial question of law, and which is disguised as which is actually a fact disguised as law, and fail to meet the stringent the essentials of the prerequisites of the section 100 of the CPC, your lordship, that is including the substantial question of law, but that is a purely question of fact, your lordship. And in further moving to the argument, and Supreme as I stated yes, your lordship. Yes, your lordship. Yes. Yes, your lordship. In the subsequent arguments in the yes, your lordship. Tribunal. Yes, your after the fact finding of this thing, your lordship, in our corrections we have included we have made liable of the actions of state, including the state actions also, your lordship, by alleging the violation of fundamental rights, and the liability is also on the shoulders of the states, your lordship. Under the PPP model, your lordship. Yes, your lordship, undoubtedly. Your lordship completely relying on the whistleblower document, which was firstly chronologically. Yes, your lordship. Your lordship. Yes. Your lordship, the specific grievance here is the axis benefit sharing, which were excluded, and the actions of state co-jointly by the actions of the gene flux resulted in the violation of fundamental rights. Your lordship. Your lordship, referring to the para 12 of proposition, the petition, under the petition we have filed before the tribunal, National Green Tribunal. The petition also implicated the Zarnovian Ministry of Innovation and Research and the Zarnovian Biodiversity Authority for their roles in facilitating project without adequate tribal consultation on safeguards, your lordship, and we have implemented, your lordship. I beg your apologies. Coming to the fact-finding issue, your lordship, and it is already stated that the general presumption in our common law system is that the tribunal is the best forum to assess the facts and credibility. The specific legislative intent behind creating the tribunal was to dispense the quick and complex climate and ecological matters, and to adjudicate the matters by involving the expert members under the section 5 of the National Green Tribunal, which states about the composition, your lordship. And to allow the reappreciation of facts here and in this appeal would violate the doctrine of res judicata, as the res judicata principle here specifically in our common legal law system states that to maintain the certainty and legal certainty and consistency, your lordship. Your lordship. I beg your apologies, your lordship. I beg your pause. Apologies, your lordship. Yes, your lordship. Your Lordship, I would beg to differ on the issue. As I stated earlier, the section 11 of the Code on Civil Procedure Code, which specifically deals about the res judicata, and where the res judicata, doctrine of res judicata has been upheld in our common law legal system, and it is settled legal principle that the res judicata principle mainly mainly it is upheld because of the fact that the should have a legal certainty and consistency in the orders, Your Lordship. To reappreciate the facts, because appeal is a continuation of the trial, Your Lordship, but to reappreciate the facts again and again would violate, not only affect the would not only affect the would not only affect the I apologize, Lordship. Going to the further issue, the tribunal due process was absolute and free from prejudice, as stated in the proposition that referring to the national. Your Lordship, referring to the
Go to section 14.
section 14, Your Lordship.
Yes,
Yes, Your Lordship.
read.
That the tribunal shall have the jurisdiction over all civil cases.
That's stop. Jurisdiction over all
Civil cases.
civil, stop there. You come to the paragraph 15 of the material, Moot material,
Yes, Your Lordship.
where the penal awarded damages were punitive in nature. In a civil case, how the punitive action may be taken against it? Whether the 14 says only in civil cases of
All-
substantial question of law. Here, the scope, the tribunal has exceeded its jurisdiction, even insofar as the punitive in nature.
Your Lordship, those were the claims of the appellant, Your Lordship, but on the
No, that is your claim.
That is the order. Order imposing penalty is there,
I beg your apologies, Your Lordship.
impugned in the subpoena.
Your Lordship, it is also been stated in the section 15 that the tribunal may, by an order, provide a relief compensation to the victims of
Compensation is different.
Yes,
Punitive. Punitive
Your
in
Lordship.
nature is different.
Yes, Your Lordship, the restitution of the property damage, and which is the collection of samples which has been done by the on the order of the tribunal, and the restitution of the environment, which under the Moot proposition 15, which states that I beg your apologies, Your Lordship, under the para 14, which states that the Azola habitat and the decontamination of Lake Azul and the gene flux was directed to pay satisfy the section 15 clause B and C, Your Lordship, for the restitution of environment, and under its competent jurisdiction it has acted under the law, Your Lordship. Directly manifest manifest arbitrariness and infringe Article 14, Your Lordship, because of the fact that under the PPP arrangement, invoking the doctrine of public instrumentality, which has been decided, which was also the state was also a co-partner in it. See, the arbitrariness which was done, the arbitrary displacement of the tribal community, and the state's preferential support to the private corporation. And Your Lordship, turning to the page, Moot proposition para 5, which states that, I beg your apologies, Your Lordship, para 6, which states that to seeking to attract global research investment and comply with the Nagoya Protocol obligations, the Zarnovian Parliament passed the Zarnovian Biodiversity Protection Amendment Act, which streamlined the research permission. It has been clearly certain that to streamline the research permissions and commercial access. And also the critics argued it weakened the regulatory oversight and marginalized the indigenous community. And it is further in the present memorial case, it is stated that the arbitrary displacement of the... Yes, Your Lordship. Our tribes...
Why did you not complain to your home?
Your Lordship...
Because you are in your country.
yes, Your Lordship.
Some foreigner is displaced.
Yes, Your Lordship.
You have a right.
Yes, Your
Why
Lordship.
did you not assert that?
Your Lordship, the tribes, particularly being vulnerable groups, and the gene flux being the multinational companies, and here the power politics and the money muzzle power plays here, Your Lordship.
Have you at least attempted to approach the government?
Your Lordship, for the first attempt which was done by the council was to file tribunal again, to file a tribunal.
After all this,
Yes, Your Lordship.
while you have been
Yes, Your Lordship. Specifically dealing with Article 21, Your Lordship. Yes, Your Lordship. No, Your Lordship, but undoubtedly it's the state, Your Lordship. I seek the permission, like 10 minutes for Your Lordship. 10 seconds for Your Lordship. Apologize.
what does the article say?
Article 12 states about the definition of state, Your Lordship. The government, the central government, the state government, other public and authorities. Your Lordship, the state action doctrine, the using the instrumentality or the agencies, which has been decided in the R.D. Shetty versus the Indian International Authority. Yes, yes, Your Lordship. Your Lordship, that is not very. Your Lordship.
Whether the intellect is performing the sovereign function.
Your Lordship, undoubtedly the state has the sovereign power, Your Lordship. That is undoubted dispute. But the auxiliary functions under the PPP model, which states the access to the villa reserve and to access the
Get the color of the state.
applying the state doctrine. Applying the doctrine of state action doctrine. It is it is certain that it is very auxiliary in nature, which similar to the functions of the state, Your Lordship. Also, Your Lordship, when the private party works so closely with the function, so as much as the state, the function of the private becomes so closely intertwined with the with the functions of the government, Your Lordship. With Your Lordship permission, seek to proceed with the other issues. The violation of the livelihood, Your Lordship, which has been specifically stated under the right to life, which is recognized under the Article 21, the right to life and liberty, which is violated by the unwarranted activities of the gene flex, Your Lordship. Your Lordship, the tribes are on the sociological and anthropological level are backward, Your Lordship. For that, our constitution recognizes the positive affirmation which has been provided in the constitution, Your Lordship. Because of the PPP model, the depletion of the azul plant was certain, and due to the losing property of the azul plant, this losing of the spiritual and the healing properties. Yes, Your Lordship. Undoubtedly, Your Lordship, the principle being it is recognized in our constitution that the ecology, environment,
Because that particular drug that they will get from the leaf of the same day.
yes, Your Lordship.
You may be replaced, you may be displaced from that place and you will be located in a different place.
Yes, Your Lordship.
But plant cannot be replaced. Or
Yes, Your Lordship. As the contention being that the balance should be maintained between the economics and the ecology, Your Lordship. That's why the balance, the principle specifically states under the doctrine of sustainability, where the balance should be maintained. We should not tilt towards one economic or to the ecology. Tilting anything or taking sides would harm any. Yes, Your Lord. A right to health is concerned, Your Lordship, not on the cost of the tribes, Your Lordship. Yes, indeed, Your Lordship. It's not absolute. It has some reasonable restriction. Yes, Your Lordship. It has some reasonable restriction, but such reasonable restrictions doesn't come into the. Yes, Your Lordship.
not only for your set of people, tribal people, it will be utilized for any other people also, not your nation. Maybe exported also. Entire world that they can have that the medicine.
Yes, Your Lordship. Yes, Your Lordship. Undoubtedly, it is the gene flux actions which are primarily responsible here, and along with that, the union of Zarnovia, which tilted towards the gene flux, is responsible here, Your Lordship. The subsequent issues will be dealt by our co-counsel, Your Lordship.
The counsel representing the respondent seeks to present issue 2 with the permission of the bench, Your Honor. I would like to add a concluding statement to issue 2. Fundamental rights pertaining to violation with regarding to ecological and environment aspect of Article 21. How does ecological and environmental aspect of 21, how is that invoked? I would like to bring that in. As well as by giving a concluding statement, I would like to move on also with issue 3. I would also deal with issue 3, whether gene flux has violated the domestic and international biodiversity framework, Your Honor. The counsel seeks permission to begin with the arguments, Your Honor. Much obliged, Your Honor. To begin with, I would like to begin with a particular quote that says, nature is a source of all material things, the maker, the means of making, and the things made. Spirits in the source of all conscious, which feels pleasure and feels pain. Your Honor, with respect to environment, like in the absence of environment or ecological health, it is also difficult for them, Your Honor. It's not only the right of the Kavanzi tribe, but also overall when we look at the environmental impact, it also affects them also, Your Honor. Without the environmental impact, it's difficult for Gene Flux to run their multinational corporation also. The counsel for the respondent would humbly like to submit that, with respect to issue 2, the fundamental rights of the Kavanzi community have been violated grossly by the actions of the appellant. The right to life, as we know under Article 21, is not a sterile and biological existence, but it is a right, as we know, to live with harmony, to live with one's environment. It means to live in harmony with one's environment and not a mere animal existence is what I would like to submit here, Your Honor, but rather the right to live. What does the right to live include? The right to live, unenumerated rights. Under Article 21, we have right to clean drinking water, right to livelihood, access to breathe clean air, and to live with dignity, Your Honor. With dignity. Your Honor, but not at the cost of the health again, because in the cost of manufacturing a drug, they are in turn polluting the environment, which is very clear with respect to paragraph 10 of the Moot proposition. and which is again causing harm to us. So, and the affordability of this particular degenerative, whatever the medicines they are, the drugs they are producing, how far would it be affordable by the Kavanzi community is another question that can come forward also, Your Honor. They can be put forward also with the immense amount of research and development that they undertake. What is the cost, or would it be affordable by us? But it is at the cost of our health is something that I would like to put forward.
If you look at insofar as your interest is concerned, see, entire the research what that could be done by them will be deprived of. See, the research is insofar as the entire human, the community as a whole. Allow them to do some research.
Your Honor, allowing, they no doubt have, do the
And
research.
insofar research is not merely insofar as any other research. It is relating to the health.
But environmental,
In
ecological
event if
aspects.
they have
yes,
succeeded in their outcome of their research, then it will, it is a good solution for many of the patients, those who are suffering from neurological problem,
Your Honor, but with
including
as
you
an-
people also.
Your Honor, I would just like to take attention. Yes, I'm really sorry
So
about
you
this,
may be
Your Honor.
displaced from one place X to Y.
Your Honor, it is not only about displacement, but when we look at our paragraph 10 of the Moot proposition, it is
Because of you people only the country is not insofar as developing. You come in the way of your entire project, stopping everything in the guise of environment.
Your Honor, another point I would like to put forth is as an MNC of a developed country, I would like to strongly put forward from Nordovia. They come here, and our culture lies in the tribes and in all our people of the country. They try to encroach into our country, which is a developing country, and at the cost of our environment and our ecological aspects, they try to make a particular world-breaking or ground-breaking research. Why is that not possible? Your Honor, with respect to the facts that are laid down, Your Honor, paragraph 10 of the Moot proposition, Environmental Assessments Report reported drastic depletion of Azula plant populations due to over-harvesting and chemical exposure. If it was there in their country, what are the basic safety standards that have to be taken? Safety standards have not been met. Here we are not lying as a barricade to their research and development, but we are just trying to protect our right and our right to life, where we are not left at a mere animal state, because as a tribe, our home lies in the forest. Our basic aspect, the river that we use, etc., everything has been polluted. Lake Azul is tested positive for chemical contaminants, and migratory bird population declined. Tribal healers reported the Azula plant had become unusable for traditional medicine, which was held or hailed as a traditional knowledge all these while, Your Honor. It becomes very pertinent to submit before this honorable court that my learned friend of the opposite counsel has also contended that they would no doubt restore the ecological losses as such, which, Your Honor, is very evident that they come to a juncture, an affirmative consensus, that they have no doubt infringed our right to life with respect to environmental and ecological losses that have caused to us, Your Honor. So this is one thing I would like to put forth. Also, when these are destroyed, it is not alone the nature that perishes, but it is a civilization where we live in. The civilization that... Yes, Your Honor, and no doubt, and all of these have been, the particular decision of the tribunal, no doubt has been in our favor, and here we are contending in... Yes, Your Honor. Yes, Your Honor.
After all efforts, you have opposed it. You have not raised your name justly.
Your Honor, that is, again, I would like to present another, from the facts of the case again. So here we have the players, that is two main authorities, the Zarnovian government as well as the MNC, which are two major and highly advanced players as compared to the tribes.
Government is your government. You should have compliant to your government.
Your Honor, we were never provided an opportunity to have a fair and equitable benefit sharing also, Your Honor.
In your country. Uniflex is a foreign country, foreign entity. It is exploiting natural resources in your country. You have not raised your part.
Yes, Your Honor. With that contention, we had approached the tribunal, and at that stage also, according to paragraph 13 again, the ministry along with the Zarnovian Biodiversity Authority contended the approval granted to... Yes, sir. The state was implemented, no doubt. It was the Ministry of Innovation and Research and the Zarnovian Biodiversity Authority, no doubt was implemented at the tribunal stage, Your Honor. According to the Moot proposition, it is, with respect to paragraph 12, it is no doubt provided that the petition also implemented the Zarnovian Ministry of Innovation and Research and the Zarnovian Biodiversity Authority for their roles in facilitating the project without adequate tribal consultation or safeguards, Your Honor. So we have tried to approach, but we weren't, because of our vulnerable nature, we weren't allowed to move forward, Your Honor, as one of the key players is our MLC. I would like to move forward by quoting that. The establishment of liability of gene flux here. Gene flux is liable for breaching all the ecological and infringing Article 21 of the Constitution of the Kavanzi tribe as such. It is humbly submitted that gene flux is a beneficiary of the public-private partnership. Assume the fiduciary duty under the public trust doctrine and exploiting Zarnovia's natural resources, which as I already told, we did come forth, but we did not have the right to be heard until and unless we went to the tribunal, and the tribunal no doubt was in our favor. Furthermore, the onus of the proof in this environmental case squarely lies on gene flux on the basis of the principle polluters pay, Your Honor. With respect to Indian Council for Enviro Legal Action as Union of India, where the polluters pay principle was for the first time introduced, quoted, and as such Vellore Citizen Welfare Forum as Union of India again, where the ratio decidendi holds about the polluters pay, it becomes very, very evident that they no doubt... Your Honor, it is only about the ecological damages that they have, and no doubt they themselves have also contended that they will no doubt restore. But I also had an interesting point, I mean, with respect to their submission that they had made. With respect to that, they had actually said that no doubt we will restore the ecological losses, but we want all the samples which are seized back. They did not, even at that juncture, they did not look towards the cultural aspect, or they did not have any cultural aspects towards the Kavanzi community, where though Azula plant was something, or the genetic resources and samples which they had taken, was a part of our traditional knowledge. And right now it has become to an unusable state, and whatever samples are available with them, that has been seized according to the decision of the tribunal. They are no doubt at a cost of returning that. That was with respect to the submission made by them. They are accepting in order to restore the ecological losses, as if it is a favor that is done to them, done by them to us, Your Honor, which is not a favor, which is not a particular favor done by them, but rather it is a mere human right that all the Kavanzi community, I would like to put forward, Your Honor. With respect to the third issue, with the permission of the bench, I would like to move to issue 3, Your Honor. Whether Gene Flux Biogenics Incorporated acted in violation of domestic and international biodiversity framework or not. Indeed, they did. First, I would like to divide it into 3 sub-issues which I would be dealing with. A, failure of prior informed consent and benefit sharing, access and benefit sharing obligations, which are very quite evident under the Zarnovian Biodiversity Authority Act, which is again no doubt in line with the Convention of Biodiversity and the Nagoya Protocols of 2010. B, misappropriation of traditional knowledge and the true nature of the public-private partnership which came in as a collaborative research project under Section 5, but later on it's true usurping the aspect of their commercial venture. It came in with the intention of a commercial venture and not a research project identity. C. Violation of international environmental instruments, the Convention on Biodiversity, Nagoya Protocol, and the domestic, as I would already be dealing with.
Under what article you claim this as your traditional knowledge? Under what article?
Under article.
Because you derive the right from the
With respect to one aspect is traditional knowledge, but the other aspect is the fund. Yes, Your Honor.
what article of you are claiming traditional right over this particular
Yes, Your Honor. I just beg to get 10 seconds.
correct.
Under the cultural and educational right, fundamental right, Article 29, protection of interests of minorities, any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture. Here we hail traditional knowledge as one of our important identity or the culture of the Kavanzi community or the Kavanzi tribe. Yes, Your Honor. Much obliged, Your Honor. With respect to the NeuroHub Discovery Accord that was entered in through by the Zarnovian Ministry as well as by the Gene Flux, Your Honor. Basically, when a PPP Accord is entered into, three main aspects, that too when it comes to indigenous knowledge and treatment as such, three main factors have to be taken into consideration. Prior informed consent, mutual agreed terms, and fair and equitable benefit sharing with respect to utilization of genetic resources. So these three important aspects have no doubt have been mentioned in the Nagoya Protocol as well as CBD and imbibed in under Section 21 of the Biodiversity Protection Act of 2002 as well, Your Honor. So the absence of consultation with the Kavanzi community constitutes a fatal breach of statutory condition.
You are referring to a contract between your government and me.
Yes, Your Honor.
And these three aspects are incorporated in that agreement.
Yes, Your Honor.
Then they have not completed with these three
Yes, Your Honor.
aspects of the matter. You should have raised a complaint. No. Now you are raising it. You are basing your case on the contract between the government and the
Yes, Your Honor.
Unified.
Yes, Your Honor. This particular, yes, Your Honor. But the aggrieved party who's been affected here is the Kavanzi community because our traditional knowledge have been traded by our government to the Gene Flux appellate. Your
You
Honor.
can have your grievance against your own government because government is having some contract with somebody because you are not the party.
Your Honor, that is one side of it, but the important side of it is what we are here pleading is for our mere right to live as a dignified citizen in the society, Your
That
Honor.
you can assert against your government, not against the foreign body.
Your Honor,
It is the responsibility of your government to recover whatever damage or whatever.
Indeed. But this particular situation came to light only after the whistle-blown documents with respect to paragraph 8 again. I would like to draw the attention to the court's attention to paragraph 8 of the Moot proposition. The leaked documents revealed that Kavanzi community had not been consulted during the approval process and were excluded from any access and benefit sharing agreement. Over 250 families were displaced due to project triggering nationwide protest. Police crackdowns or demonstrators led to national and international outcry. This is one aspect of it. The other aspect, no doubt, Gene Flux as well as the government have been involved in corruption also, Your Honor, with respect to the leaked documents and whistle-blown documents. Paragraph 9, no doubt, states about the Zarnovian Anti-Corruption Bureau registered FIR number 14/2025 under the Zarnovian Prevention of Corruption Act 2005 against several officials and Gene Flux alleging bribery, abuse of office and criminal
It's only
misconduct.
allegation, it's not been proved.
Yes, Your Honor, it's pending. It's still pending before the
Now
court.
you say that they have committed
It is with respect to the whistle blown documents, I would like to play.
Only a statement.
It is a particular fact that is being which has evidence with respect to documents, Your Honor. It is just for the. I just wanted to bring this particular fact that there's a case, a corruption case running.
Is not proof of it.
Indeed, Your Honor. Apologies for that. Again, going back, drifting back to.
To say they have committed the act of corruption, that has to be proved by the in the competent court of law. That is not there.
Indeed, Your Honor. But again, with respect to one of the contentions made by my learned friend of the opposite counsel, who said, my learned friend of the opposite counsel said, with the cooperation of the tribes, they could get the indigenous knowledge. With the cooperation of the tribes. There was not only any other way to obtain the said traditional knowledge, but only with the cooperation of the tribe. How ironical is it, Your Honor, I reiterate, how ironical is it for an MNC like that of the appellate to submit in front of this honorable court that they were not a part of any other means, but only with the cooperation of the tribes, where the tribes weren't even aware, the tribes weren't even given any benefit, or if the tribes were aware, and if they did seek the cooperation of the tribe, then no doubt the tribe would have claimed for their access and benefit sharing. The tribes were no doubt ignorant of whatever access and benefit sharing they had to know, and all of this came to light only after the leaked documents through the whistleblower, Your Honor. If the court does not have any other clarifications, I would like to move ahead. Again, with respect to NeuroHub Discovery Accord, it came in, the particular gene flux came in as a collaborative research project, but later they tend to become tend to have a commercial venture, and as well as they also had a malified intention of filing a particular international, filing a particular patent again with respect to the traditional knowledge and whatever biological genetic resources and traditional knowledge derived from it in the European Patent Office and Nordovian Intellectual Property Registry for a neuropharmaceutical derived from Azula. But the main important aspect to note here is, if there was a bona fide intent, they would have no doubt disclosed the biological origin and associated traditional knowledge. But with malified intention, they haven't disclosed the biological origin or associated traditional knowledge, which is one of the important aspects while filing a particular patent, Your Honor. Again, with
What do you say about the aspect of the jurisdiction order with regard to patent? Whether the tribunal has the jurisdiction to decide on the patent?
Your Honor, the main issue here evolved around ecology and environment, where there was environmental contamination and as such.
I'm asking that with regard to registration of patent, whether it with regard to biodiversity or whatever, whether the tribunal gets the jurisdiction to decide it. Is it not beyond the jurisdiction of the
Your Honor, I would just like to have 10 seconds. Your Honor, I would like to move ahead with the next. Yes, Your Honor. As such, with the tribunal's directions, whatever the tribunal has directed with respect to the various remedies it is given, with respect to immediate and permanent revocation of gene flux's access to Villa Reserve, seizure of all biological samples collected in violation of the law, and implementation of a restoration package on the principle of polluters pay. This included ecological rehabilitation of the Azula habitat because because there has been an infringement of Article 21 with respect to this. Furthermore, Gene Flux was directed to pay compensation, and which my learned friend has himself contended that he would no doubt it is his duty in order to take up and restore the ecological losses, which I am. Indeed, Your Honor. Yes, Your Honor. Losses suffered due to the project's implementation. The tribunal's directions are justified, proportionate, and necessary remedies have been provided, Your Honor, with respect to that. So, whatever the appeal and contentions held by the appellants with respect to fair and benefit sharing have been provided. No, benefit and access benefit sharing have not been provided. The Kavanzi community have not been sufficiently consulted with as such, and whatever damages are justified are punitive measures for wrongful contravention, and it is not as arbitrary benefit sharing, but for whatever wrongful contravention that has been undertaken. And the directions uphold the true legislative intent of the Zarnovian Biodiversity Protection Act to secure access and benefit sharing also. With the court's permission, I would like to conclude my argument, Your Honor. It is safe to conclude before this honorable court that Gene Flux Biogenics Incorporated has acted in a clear and irremediable violation of both domestic and international biodiversity framework by not providing a fair and equitable benefit sharing to the Kavanzi community as such, and violating the fundamental rights of them. The appellates constitute willful biopiracy by not disclosing the biological origin as such, and the access and benefit sharing and prior informed consent and the subsequent malified filing of a patent, which unilaterally usurped Zarnovia's sovereign genetic resources and Kavanzi community's traditional knowledge, as we hail, Your Honor. The tribunal's directions, including the punitive damages, are therefore justified, proportionate, and necessary to uphold the fundamental principles of fair and equitable benefit sharing and deter future acts of such MNCs or any such industries of environmental and cultural exploitation that we hold, Your Honor. With the permission of the bench, I would like to recite the prayer, Your Honor. Wherefore, in the light of issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully prayed that this Honorable Supreme Court of Zarnovia may be pleased to dismiss this instant appeal filed by Gene Flux Biogenics Incorporated and uphold the decision of the Biodiversity Tribunal holding Gene Flux liable for biopiracy and causing significant environmental harm, and pass any other order, direction, or relief that it may deem fit in the interest of justice, equity, fairness, and consciousness. Much obliged.
With all humility and great due respect to the learned respondents, I would like to submit to the bench that most of their arguments were premised on the assumption that we are running away from owning of the responsibility and that we are contesting the jurisdictional tribunal, which we aren't. And as the learned appellant claimed, we have never claimed that we are doing a favor to them. We only submitted. As the learned respondents claimed, we are not doing a favor to them. We're only adhering to the obligations we have. Your Lordships, the inadvertent consequences of a legally sanctioned project doesn't nullify the legality of the action. Therefore, this order of the seizure of biological samples that are duly collected doesn't stand the test of law. And Your Lordships, the present appeal does involve substantial question of law, the most important being the order of seizure of duly collected samples, which has the potential to treat the prevalent neurodegenerative diseases, and this obstructs the public's right to have an efficient medicine, Your Lordships, and also of the appellant's right to work on the sample that was duly collected, and a lot of research and investment was done. Your Lordships, the consequences of a project have been examined. I would like to highlight the magnanimous character of this reserve forest. It houses 50% of the biodiversity. All that we have access is to one endemic plant and nothing else. And all that we have operated in is in a limited stretch of land, and the displacement is in accordance with the statute. As far as the access and benefit sharing is concerned, Your Lordship, under 21 clause 2, 328 of the compendium, it could take part, pardon me, Lordships, it could take part in any of the forms, including payment of monetary compensation, which has been the case in our present deal. And access and benefit sharing agreement means a certain percentage of profit that accrues subsequent to the commercialization of product invented on the basis of a drug, on the basis of materials collected from them or from their traditional knowledge should be given to them. This will happen subsequently when it is commercialized, Your Lordships. Grateful, Your Lordships.
Of course, it can.
Again, from my learned friend's statement or submission here, saying, or the rebuttal saying here that he would of course, they would of course own up their share of whatever has happened here. So this again clearly mentions that they have no doubt are have infringed, or they have themselves have affirming that they have infringed the said aspects as such. And henceforth, the main aspect of the civil appeal filed here with them is again with respect to only getting back the seized whatever the seized materials as such by the Biodiversity Tribunal, and no other bona fide intent. So with this, I would like to conclude my sub-rebuttal saying this particular instant appeal should be dismissed because the main intent is a malified intent behind it of only getting whatever samples were seized by the Biological Tribunal, and with no other aspects as such, Your Honor. Much obliged.
you did well actually. We are both of you are good in facts is concerned, and what is the law required to be looked into in the facts and circumstances of the case. But of course, so by you are not at insofar as completed law. Of course, many aspects is concerned. You are try to answer all our questions. You should be appreciated always. But only thing is, see, moot court is concerned. Normally, just I used to tell the entire, not only you two teams, all the teams is concerned. So you must, in each of the college, must have a one lecturer exclusively have to take care of the moot court is concerned. So better take his guidance. If it is a practicing advocate, always it is on the better footing is such. So both of you can do that. I think you did well actually.
A very good evening to one and all present here. With immense joy, we welcome you all to the valedictory ceremony of the 3rd All India Moot Court Competition 2025 hosted by Soundarya College of Law, Bangalore. To commence the valedictory ceremony, we now invite Ms. Shriya, Student Moot Court Convener, 4th year BA LLB, to deliver the welcome note and extend a warm welcome to our dignitaries, participants and guests.
Good evening, everyone. This is Shriya U, Student Moot Court Convener, Soundarya College of Law, Bengaluru. It gives me a great pleasure to extend a warm welcome to each one of you to the grand valedictory function of the 3rd All India Moot Court Competition at Soundarya College of Law. Over the past 2 days, we have witnessed intense rounds of arguments, debates and rebuttals, all marked by passion, precision and the true spirit of advocacy. These sessions have been guided by our knowledgeable and learned judges, and today's finals have been graced by the presence of 3 eminent personalities, whose presence truly adds prestige to this event. It is a great honor and privilege to welcome our chief guest, Hon'ble Mr. Justice E.S. Indires, Honorable Judge High Court of Karnataka, and Honorable Administrative Judge, Bengaluru South. We welcome you, sir. I request CEO to hand over the saplings. Thank you, sir. We are equally honored to welcome our special invitees, Mr. S.S. Mahendra, former Principal Government Advocate, High Court of Karnataka. We also welcome Professor Dr. Sathish Gowda N, Registrar Evaluation, Tumkur University. We warmly welcome our patron-in-chief, Shri Kirtan Kumar Yam, CEO, Soundarya Group of Institutions. We are delighted to welcome Advocate D.M. Hegde, Editor-in-Chief of Vakila Vahini, a law magazine which reflects our legal community's intellect and creativity. Welcome you, sir. We also welcome Mr. Chandrakant Patil to this event. We welcome you, sir. And we extend a special and heartfelt welcome to Mr. Vishwas Puttaswamy, Principal, Soundarya College of Law. I take this opportunity to welcome all 41 participating teams, the mooters and the researchers who have traveled from across India to be part of this competition. You have been heart of this event. A heartfelt welcome also to our respected faculty members, the Moot Court committee conveners and all the student volunteers who have worked tirelessly to make this competition a grand success. As we gather here this evening, it feels both a moment of pride and a touch of sadness. Pride because we have successfully completed another edition of this national competition, and sadness because this wonderful journey has come to an end. Once again, a hearty welcome to one and all. We are truly proud to have hosted you here at Soundarya College of Law, and we hope you carry back memorable experiences and friendship along with your learning. Thank you.
Thank you, Shriya. We now invite Mr. Tikshan M. Bonsley, Student Moot Court Convener, 3rd year BCom LLB, to introduce our chief guest, Honorable Mr. Justice E.S. Indires, Honorable High Court Judge, High Court of Karnataka, and Honorable Administrative Judge, Bangalore South.
Good evening. I am Tikshan Bhonsle, convener of Moot Court Society, Soundarya College of Law, and it gives me great honor and pleasure to introduce our chief guest for today's All India Moot Court competition, Hon'ble Mr. Justice E.S. Indires, Judge of Karnataka High Court and Hon'ble Administrative Judge, Bengaluru South. Justice Indires was enrolled as an advocate with the Karnataka State Bar Council on 12th of January 1996. Early in his legal career, he joined the chambers of Srimati B.V. Nagaratna, who is now the Judge of Supreme Court of India. Over time, he served as panel advocate for various public and quasi-governmental bodies such as Mysore Sugar Company, Karnataka State Financial Corporation, Karnataka Marketing Federation, Oriental Insurance Company, United India Insurance Company, among others. Sir also contributed to legal education. He was a part-time lecturer at Sharda Vilas Law College, later taught at Havanur College of Law and at the Bangalore Institute of Legal Studies. Further, Sir acted as a regular faculty member at the Karnataka Police Academy, lecturing on subjects such as preventive detention, the Gunda Act, and conservation of foreign exchange and prevention of smuggling activities. From 2009 until his elevation, he served as government pleader and subsequently as additional government advocate. Justice Indires was appointed as the additional judge of Karnataka High Court on 7th of January 2020 and was later confirmed as permanent judge on 25th of September 2021. Some of his notable judgments include, in a Hindu Marriage Act matter, he held that sale of property attached toward permanent alimony is constrained by Section 64 CPC and Sections 52 and 100 of the Transfer of Property Act. In a matter containing cooperative society rules, he ruled that an auction purchaser who fails timely deposit forfeits claims and becomes liable for losses from subsequent sales. On arbitration law, he held that an erroneous portion of an arbitral award may be served under the proviso of Section 34 Clause 2 rather than ordering a fresh arbitration. In civil procedure matters, he has asserted that ex parte decrees must rest on careful reasoning and mere default should not automatically lead to decrees without scrutiny. In proceedings under Section 125 CRPC, he observed that technicalities should not defeat the object of safeguarding the rights of wives and children. These judgments reflect his commitment to upholding access to justice and preventing undue procedural rigidity. I now request Honorable Mr. Justice E.S. Indires, High Court of Karnataka, to address the gathering.
ಎಲ್ಲರಿಗೂ ನನ್ನ ನಮಸ್ಕಾರ. Shri Mr. Kirtan Kumar, CEO Soundarya Group of Institutions, and my friends in bar, Shri S.S. Mahendra sir, Shri Egide, Shri Patil, the principal of the institution, and my academic friend, Shri Dr. Sathish Gowda, faculty members of the institution, administrative section, students, participants, ladies and gentlemen. Dear friends, we have just witnessed the final round of the Moot Court is concerned. In fact, when the material was given to me, sir, this is the facts of the case, this is on which the entire the arguments will be addressed by the learned counsels in the competition. I saw that. Reading the Zoroastrian, that country's name is very difficult. But one thing is definitely true. The ultimate object of the purpose on which the entire material has been faced is to protect the environment in the society. I feel to say that this is the one institution in law has taken care of the ecological balance in our vicinity. I've witnessed, in fact, I myself has on 2 occasions, one in Mandya district, nearer to Srirangpatna, and another one is near Nagamangala, where insofar as the institution, in collaboration with the district administration, have planted many seeds. Of course, dear friends, I felt it that probably the MC Mehta is studying in this institution. Because Shri MC Mehta is the senior advocate of the Supreme Court. In 87, that he has filed insofar as the tanneries case is concerned, year 1987 Supreme Court, and 88 also, and also another one in another in so far as a child, the finger is how far it can be used for exploitation of the child is considered under Article 23 is concerned. Dear friends, insofar as the moot court is concerned, why the moot court has to be conducted by the institution? Insofar as any other profession is concerned, whether it's engineering, medicine, or any other professional course, management course, other than law, where there is no much insofar as the intricacies between the societal interest is there. But insofar as the legal profession is concerned, where all of us know the advocates or the legal fraternity have been regarded as the social engineers. If the profession has been considered, the advocates or the lawyers, as the social engineers, and it is our duty to protect the society, and we have to strengthen or to vindicate the rights of the people, and also we are aware about the many facts that most of the members of the Constituent Assembly were from the legal fraternity, that to Allade Krishna Swami or Ambedkar ji, and many were there actually. Kunzru, they're all very great, the founding fathers of our Constitution. Today we survive only because the entire country survived because of the Constitution. Constitution is prepared by none other than the social engineers. They are nothing but the legal fraternity people. Why I am saying all these things, dear friends? Firstly, I congratulate each one of you having taken the good profession for your career is concerned, compared to any other profession is concerned. 2 things are there. One is, I need not become just vindicate the rights of the parties and I have to argue for the people and societal interests. Even I have to grow myself and my responsibility towards my society, my family, and it is my duty to take care of my parents. If such being the case is concerned, nowadays the legal profession is very lucrative, very lucrative. Actually, when last Saturday, when I had been to the Bhopal, we have a judicial academy. Honorable Justice U.U. Lalit had a gauge class for us. Then just it was transferred in my name. Justice U.U. Lalit, when he was the advocate, somewhere in 2013 or 14, I have assisted his assistants, not assisted him. I have assisted his assistants in one of the, then it was a very highly political issue before the full bench of the High Court of Karnataka. Then I thought of, then asked his colleague, what is the fee of Justice U? Then he was U. Lalit, he was a Solicitor General then. What is his fee? He was earning in 2012, 13, 14 around 1.5 crores per day, actually. Of course, the Modi ji has made him to judge of the Supreme Court. He has lost his revenue. Of course, but it is a gain to the judiciary. Reason is quite obvious. Even take for an example, I had an occasion to say that in one of the, in 2020 when I became judge, Mukul Rohit had appeared in one of the matters. I was sitting with, as a puny judge, I am a puny judge, with His Lordship's Arvind Kumar sir. And Justice Arvind Kumar sir asked Mukul Rohit, how many matters you have? He said, one is Chhattisgarh, another in Mumbai, Chandigarh, and 2 in Supreme Court, and before the High Court is 1 matter. Mukul Rohit charges, all of you know very well, 25 to 30 lakhs per appearance. 5 cases into 25. Whether it will be adjourned, whether it will be effective hearing will be there. Why I am saying all these things? Insofar as the profession is concerned, nowadays, earlier when, I think I am telling about the 20 to 30 years back, it's very difficult for us when we was initiated. And unless my father gives me money for me, it's very difficult in the earlier stage is concerned. It's very difficult then. But nowadays it cannot be. It is not like that. Changes. See, many things that we can see. The financial aspect is concerned, that will take care, provided if you maintain integrity, hard work, and committed to the profession. If these 3 things are there, commitment to the profession, hard work, coupled with maintaining the integrity in the profession, definitely, dear friends, each one of you will become and reach the highest pedestal in the society. No doubt, so far as the said aspect is concerned. Insofar as the other aspect, insofar as the, see, not only I have to be financially sound, simultaneously insofar as I have to get pleasure, I should be satisfied. In the end of the day, if I go home and sleep, something will be, will be there in my mind. I did something today for the society. That you can find only in legal profession. See, 2 things. One is financially you will be in the higher pedestal. Secondly, you have a self-satisfaction in the life. Something is there. I achieved something else. These are all the things we find, dear friends, only in the legal fraternity. That's why you have chosen a appropriate the profession for your career is concerned. Don't worry at all. Now we have crossed 20th century. Now we are in 21st century. The entire gamut of law is changed, and the way in which everything will be in your footprints, wherever fingerprints. Where earlier when we used to be study, we used to go to library to look at the cases. Even when we started practicing, we used to go to the library to check how many cases on this point, precedent, what is the law on the point, how the aspect is considered. But nowadays, technologically now we are improved. When technology is coupled with hard work, dear friends, definitely it will be utilized by each one of you for upliftment of your career in the society, career in the profession. Definitely, dear, if you choose a particular senior for yourself, after 5 years course, I appeal to each one of you, dear friends, please don't start your independent practice. Please go to a senior, practice minimum 4 to 5 years. Don't become senior in 3 years or 2 years, or it's very difficult, because you may be good in English, you may be good in searching cases, you may be good in so far as understanding the particular law to the fact is concerned. But one thing is clear, insofar as legal profession is concerned, procedural aspects. Procedural aspects. We may address very good argument in the court, but the small question, if a learned judge said, how much court fee you have paid for this, is very difficult to answer. What's the jurisdiction in which that you approach a court? It is very difficult to understand. These are all the intricacies that you can learn only if we join a law firm and join with work with a senior for at least minimum, nowadays I will say, 4 years. I think nowadays, you must have seen recently the judgment of Hon'ble Supreme Court insofar as to take up the junior division examination, civil judges. They say that minimum 3 years is mandatory. Because the reason is, we must understand, take for an example, if a case has come, if a client has come to our office, we look into it. We look at the facts of the case. Now we understand which law is applicable, whether it's a partition suit, declaratory relief, or whether a mere injunction is concerned, or anything part insofar as the other, the portion of the part of the law is concerned. Then the question is drafting. So don't go to the draft, assimilate the entire facts, condense it, then you start pleadings, because pleadings plays a vital role. If your pleadings is good, even take for an example, if you are not able to address the arguments in the court, normally the judges will look into what ground has been urged in the petition, your pleadings plays. Because in the event if the learned judge does not look into your grounds urged in the petition, if such a judgment is rendered, if it is taken up in appeal, normally the appellate court will straight away grant stay of that order. Reason is, pleadings makes the foundation for the case is concerned. So far as is concerned, understand the facts of the case, look into which law is applicable for a case, what are the procedural aspects. Procedural aspect means court fee, cause of action, then who is the aggrieved person, and what are the documents has to be included, what should not be included, because whatever the client will say, we cannot, it will not reflect in our petition. Certain only in the material facts that you know very well in Order 6, Order 7 and Order 8 is concerned. Then pleadings, write the pleadings very nicely. Then the arguments is concerned. So trial is concerned. If our trial is concerned, dear friends, this also again I appeal to you, whenever you find a time, please go to city court. Follow a particular case, how the examination will be conducted by the learner counsel. Many times how the cross-examination will be posed, and whether re-examination is required in a case or not, how it will be decided by the learner counsel representing the parties. See, if you look at the procedural aspect is concerned, because you need not cross-examine the witness in all the cases. Sometimes if something is admitted in either in pleadings or in the admission in admission in the examination chief is concerned, you need not cross-examine. If you cross-examine, then you will also sometimes lose the case in such situation. Therefore, apply your mind. Then the next one is arguments is concerned. Insofar arguments is concerned, dear friends, even now also I am telling you, please come to the constitutional courts. That is High Court. If you find any time during your recession of your session, that is insofar as during the period 1 semester or another, you have 10 days, 15 days time, please go to Supreme Court, Hon'ble Supreme Court. Why I am saying all these things? Today, in fact, the 75th, today this is 11/10, 75 years of completion of practice by very great jurist of our country. That is, today it was held in A.K. Parasharan. Today it was held insofar as in Madras, Chennai is concerned. Almost 6 to 7 judges of the Supreme Court were there. If you look at the arguments advanced by the Parasharan, because I had an occasion when the learned advocate was arguing a matter before Justice Kumar relating to the Fulavati case is concerned. He was the one who was arguing because he's a very good brain in Hindu law, insofar as India is concerned. As and today, how he argues well, how he meticulously makes a point, what things has to be done, how it has to be argued in a matter. These are all the things, dear friends, nobody will guide us. Nobody will teach us. Nobody will, insofar as nothing that we can read it in the law books is concerned. These are all the things we learn only if we sit in the court hall and imbibe what are the arguments will be addressed by the learner counsel. These are all the things is concerned. If you find a time, look at the arguments that may be. Now we have very few legal minds. Many of them. Now we don't have ANC, not the CK Daftari, or any other. We have only few. Take KK Venugopal ji, or the many people now are the Chidambaram ji. So look at how they will argue the matter. Sometimes we feel that. See, if a learner senior counsel appear in a matter, the judge will normally grant stay. Why, if I appear in the matter, why the judge will not grant stay? Sometimes it will be there, insofar as a Patil's brain is concerned. I will tell you, Mr. Patil, only thing is, that's the generation is concerned. Because learned senior counsels, they say, maybe your petition runs about 50 pages. They know which point has to be raised first, which point should not be raised on the later stages concerned. Maybe a very good case on merits. Sometimes we lose the matters only because of lack of our knowledge, or else we have not put it in a formidable way how it has to be argued in a matter, or else take for an example, we irritate the learned judge because of our behavior is concerned. These are all the cumulative effect. Cumulative aspects will be considered while insofar as delivering a judgment is concerned. Be submissive. Nothing will be there. See, you are wearing a coat, black coat. Why we wear the black coat? It reflects the pain of my client. The black coat, why the advocates will wear? Because of they carry the pains of the client. They are appearing on, because that's why they say, sign the wakalatnama. That is power of attorney. Wakalatnama is nothing but power of attorney. Because they carries the pain of the client and they put it in a right way. Nowadays, dear friends, because of the technology is concerned, earlier the advocates used to say, I argued your matter for 5 hours, despite not even 5 minutes. Learned judge has dismissed your petition. You don't have a good case on facts. So I think probably you don't have good faith. I lost the case. Nowadays, dear friends, before coming over to your office, client will already visited 3 advocates' office. He assessed advocate A, advocate B, advocate C, which one is better. And nowadays, because of the streamlining and the video conference is concerned, normally we used to say if the advocate is arguing the matter, clients will follow what point he will argue, what point he should not argue. Many things, nowadays everything will be the fingerprints. AI is there. They know very well. I think last week someone has asked why there is a matrimonial matter. Then we put a question to the in mediation. Why did you file case for for the dissolution of marriage under cruelty 13(1)(a)? Then he saw, how did you get all this material? The husband say that, sir, I given facts to the AI. It gives me result. I filed the case. Then means I will definitely succeed in the matter. That's why I filed it. What bapre? See, this is because technology is there. Utilize the technology for enhancement of our knowledge. Dear friends, whatever may be the technology is advanced, but one thing is very clear. Our original thinking will not be suppressed, will not be supplemented, will not be supplanted by any other technological devices concerned. Original thinking should be there in our mind. If we do not have original thinking on a particular aspect, then it's very difficult. Technology is only aid. It is only support your thinking capacity, but it will not be considered as one of the tools. That's all I would say. One of the tools, but it's not a predominant one. Otherwise, if we work hard, if we maintain integrity in the profession, if I have the qualities of a good advocate, then only I will come up. Sometimes a first 1 to 10 rank student may not become a good advocate. Sometimes a person who has only got the minimum marks may become a very good advocate in the court. He may earn money like anything, but Why I am saying all these things? Insofar as the advocate is concerned, not merely, dear friends, what the law books is give us does. Many times we require common sense. Common sense plays vital role. If you have a common sense, with the aid of law, with hard work, definitely we will come up in our professional course is concerned. Nextly, I would say to the law students is concerned, apart from all these things, please read the autobiography or the biography of great legal minds, whether Roses in December, or in Chinna Predi's case by R. Venkatramani, and many books are there. I think Making of Constitution by H.R. Kannaji. See, many autobiographies are there of the learned judges. Please read it. I think recently I have had an occasion to read the. Please get a book in your Fearless Judge by Justice, former Chief Justice. Just I am not able to remember. It's a Fearless Judge, and Hamadi, Honorable Justice Hamadi. Please read that. See, came up from the district judge and rose up to become the Chief Justice of India. See, he has explained how he has struggled, how he has overcome only because of his sheer hard work. These are all the things you must know. Dear friends, one thing is clear. Without the aid of the elderly people or the persons who have experience in law, experience in a field, is very difficult. Move with those people. Move with those people. And whenever you join any law firm thereafter, please think in that law firm both have civil and criminal cases that they have to handle. Secondly, think over that firm is having both appellate stage and as well as the original side. Otherwise, you will be confined to the only trial court. If you go to an advocate when you say having only trial court matters, then you will become a good advocate, but you will confine yourself to the trial court. You don't have anything in so far appellate stage is concerned. If you join appellate stage, then you don't have any procedural aspect is concerned, because procedural aspects we learn only in the trial courts is concerned. Therefore, these are all the things that you must have before joining any law firm, both civil and criminal, both insofar as the original side and the appellate stage, and nextly insofar as even otherwise taking into consideration, dear friends, I would say, we need to have a lot of patience insofar as our profession is concerned. That carries a lot to understand how to maximize our knowledge is concerned. So with this, I think the institution has invited me for this, and the Soundarya group of institution is doing very well, and it's a good platform for not only the participant, dear friends, even for the students of this institution, because conducting a moot court is not that much easy. I'm aware, insofar as from the financial aid is concerned, it requires a sky. Secondly, and you will interact with different students of the institutions. See, interaction with them, or in participating in so far arranging all these things, along with the learned teachers are concerned, a kind of a reflective thinking will be there in our mind is concerned. It will blossom our mind. It will enhance the personality in this personality insofar as the career is concerned. Apart from this, then in a given case, you will also read the very same case. Then you will know what is the facts of the case, what is the law on the particular fact is concerned, and what are the things has to be considered insofar as the arguments is concerned. These are all the things, dear friends, we learn only if the college conducts such programs. Really, the institution has taken, because I was so happy to say it's the third All India Moot Court competition. I think majority, more than 40 colleges have participated, and it's of course not small number, it's a very good number according to me. And moreover, for 3-4 days, or probably insofar as the students is concerned, you interacted with many people, then you will also become the lawyer in short days. Then if you have a friends, then from check Jodhpur or check for an example, the Delhi or Calcutta, see your interactions will be there. Definitely it will enhance your knowledge is concerned. Apart from this, dear friends, so far a moot court is concerned, of course, I have my reservation and not about the today's the problem is concerned. It should have been posted for admission. Last word it say that posted for final hearing. It should have been posted for admission, not for final hearing. Final hearing means substantial question of law is already framed. Then only it will be posted for final hearing. If the matter is final hearing, posted for final hearing, there must be an admission stage is already concluded and substantial question of law is framed. That's one aspect. Don't get the facts of the case for nearly 3, 4, 5, 6 pages of these countries where we cannot remember. Take a case of specific performance. Case 1, declaration suit. It's a very small case. Do a research on the particular point. Give it to the students for their response. Or even take for an example, partition suit is concerned. How the law has been developed insofar as Mitakshara, or whether it's a Dayabhaga, or insofar as the interpretation relating to section 14 of the Hindu Succession Act, insofar as the woman estate is concerned. See, these are all the things which is very difficult to understand. So, therefore, what I am requesting to the Mr. Kirtan Kumar sir and the Shri Vishwas Putswamy sir, next time, give a very simple case for them. You give them, let them research on a particular point. Because this problem today, of course, that is very important insofar as the ecology or the environment is concerned. Really is a good problem, no doubt, regarding the protecting the interest of the vulnerable people from the partnership agreement between the state and the one another, the INC is concerned. But what I'm saying, these are all the things where the students, you have to work on this aspect is concerned. And one thing is, dear friends, every day we are student of law. If anyone says, sir, ನಿಮಗೆ ಎಷ್ಟು ಗೊತ್ತಿದೆ ನಿಮಗೆ law ಅಂತ ಕೇಳಿದ್ರೆ ನಾನು ಹೇಳೋದಷ್ಟೇ, a drop in Arabian Sea. Law is very ocean. Every day we are student of law. Of course, unless the arguments will be addressed by the learned councils, it's very difficult for the learned judge to write the judgments. That whatever we write the judgments will be based on the arguments addressed by the learned council. Therefore, what I am saying, be perfect in your professional career is concerned. If you work for, I think when I was 98, when I joined the bar, the then the judge of the High Court, now the Justice Vishwanath Shetty, Sahib ಹೇಳ್ತಾ ಇದ್ರು, if a advocate work for 10 years for a donkey, he will become a horse in the race thereafter. If you work for 10 years meticulously, like a donkey will not look into it. Whatever the master will put, the weight, just it will carry. If you work for 10 years like that, after 10 years, you don't have even time to keep money also sometimes. That provided that 10 years is very important, a foundation for you. So work hard, make use of the such programs conducted by the institution. And secondly, only 2 aspects I will tell you and conclude, that obey the rule of law principles enunciated by the Constitution. This country has given everything for us. Today we are here. ನಾನಿಲ್ಲಿ ನಿಂತಿದ್ದೀವಿ, ನಾವೆಲ್ಲರೂ ಉಸಿರಾಡ್ತಾ ಇದ್ದೀವಿ. This air is not belong to me. Every day we will have 3 meals. Nothing is belong to me. That is also belong to this motherland. And so far as everything is belong to this country, please see to it that, as Abdul Kalam ji said, that you need not do great things. in this country. Just mere, you need not become a prime minister or a chief minister or a chief justice of India or the institution head. You need not become good. Even a small thing you can do for the country, that itself is sufficient. So love this country, and this country is having a rich culture. See to it that it will be protected by obeying the constitutional values. That's one. Secondly, insofar as the students is concerned, love your parents. Parents are like eyes for us. But for our parents today, all of us here only, they are the one who shaped us. So the parents plays vital role, because today even 1 lakh rupees is not a big amount for me. But for my father, when I was a child, 10 rupees was a good big amount for him. Today, insofar as today we are here, only because of our teachers, our parents, and the blessings of elderly people. With this, I will conclude. Thank you one and all.
Thank you, sir, for those inspiring words. We now invite Mr. Mithilesh, third year BCom LLB, to introduce our special invitee, Mr. S.S. Mahendra, former Principal, Government Advocate, High Court of Karnataka.
Thank you, Chitra. Good evening, everyone. It gives me great pleasure to introduce Mr. S.S. Mahendra, a highly respected advocate at the High Court of Karnataka. Mr. Mahendra has been practicing law for over 3 decades and has served in many important roles during this time. He has represented both central and state governments, serving as Central Government Standing Counsel, Additional Government Advocate, and most recently, Principal Government Advocate before the Honorable High Court of Karnataka. Over the years, he has handled a wide range of cases, from criminal, civil matters to mining, corporate disputes. His deep understanding of law and calm courtroom presence have earned him great respect in legal community. He is also empaneled as a legal advisor for legal institutions such as State Bank of India, Canara Bank, Vijaya Bank, Kotak Mahindra Bank, KPTCL, and BESCOM, and among many others. Beyond the courtroom, he has actively contributed to mediation and conciliation, helping parties find peaceful resolution, and has served as conciliator in Lok Adalat and at the High Court of Karnataka and City Civil Court. What stands out most about Mr. Mahendra is not just his vast experience, but his continued dedication to fairness, justice, and mentorship with the profession. We are truly honored to have you here, sir. Now I request Mr. Mahendra to address the gathering.
Good evening, everyone. This is the very difficult part of the event, because I am not used to public speaking. Honorable Justice Mr. E.S. Indires, Professor Dr. Sathish Gowda, special guest, respected Chairman, Principal, Dean, faculty members of Soundarya Educational Trust, distinguished guests, and dear students. It is truly a privilege to be here as the chief guest for the valedictory function of 3rd All India Moot Court Competition 2025. And it's a special moment to share a dais with one of the finest judges of High Court of Karnataka, Mr. E.S. Indires. First and foremost, my heartfelt congratulations to the proposed winner of this event and participants for making this event such a successful. Over these days, what you have scene is not just a contest of legal arguments, but a celebration of law itself. Its logic, its discipline, and its power to shape minds and society. As practicing advocate, I can't tell you how happy it makes me to see this level of enthusiasm for mooting. A moot court is not just an academic ritual. It's a mirror of real courtroom. It's where law meets language, where reasoning meets restraint, and where confidence meets courtesy. It's where young advocates begin to discover their own voice. Let me share something personal. I still remember my very first case as an advocate. My hands were shaking, my heart was racing, and the judge felt like a mountain before me. In the middle of my submission, the judge asked me a sharp question that caught me off guard. For a moment, I froze, but then I took a breath, trusted my preparation, and answered the best I could. I didn't win that day, but I walked out feeling like I had grown 10 steps as a student of law. That experience taught me something I carry with me even now. In law, courage and presence of mind often matters as much as the strength of your arguments. The winners of this competition, congratulations. Your performance reflects not just preparation, but also clarity, confidence, and passion, the hallmark of fine advocacy. And those who did not win this time, remember, every moot is a learning experience. Some of the best lawyers I know didn't win their early moots, but they never stopped learning. And that is what made them who they are today. I also want to acknowledge the incredible efforts of faculty members, judges, and volunteers. Your hard work and commitment have made the competition run smoothly, and it shows. What I have witnessed here speaks volumes about the promise of the next generation of legal professionals. If I may add a small thought from my own journey, I believe the real heartbeat of litigation is in the civil courts or trial courts. That is where evidence is tested, documents are marked, witnesses are examined, and stories taken shape. It would be wonderful to see moot competition slowly bringing in elements of trial advocacy, so students get true taste of how cases are actually built from the ground up. It's in those trial courtrooms that many of the learned the real craft of being a lawyer. Therefore, I request Mr. CEO and the persons of this institution to incorporate the trial part of the advocacy into moot, so that it will educate the lawyers to become real lawyers in the real life. In this profession, success isn't just about how sharp your mind is. It's also the strength of your integrity. Law is noble calling. It demands not only skill, but also conscience and character. A future advocates always remember our duty is not only to our clients, but to the cause of justice itself. Let me end with a thought from one of the greatest jurists, Shri Nani Palkiwala, who said, the Constitution is not a mere lawyer's document. It's a vehicle of life, and its spirit is always the spirit of the age. Dear students, you are the spirit of the age. You are the bridge between the law and life, between the principle and practice. Carry that spirit forward with courage, humility, and commitment. Thank you for inviting me to share this special moment with you. Congratulations once again to all participants, and my very best wishes for your bright and meaningful journey ahead. Thank you.
Thank you, sir, for your thoughtful words. To introduce our next special invitee, Professor Dr. Sathish Gowda N, Registrar, Tumkur University, we invite Ms. Ramita from first year BCom LLB.
Professor Dr. Sathish Gowda N is a distinguished academician and administrator, currently serving as Professor of Law, University Law College and Department of Studies in Law, Bangalore University, and Registrar, Evaluation, Tumkur University. He is also the Dean, Faculty of Law, School of Legal Studies, Kannur University, Kerala. He holds several eminent positions including Syndicate and Academic Council Member, Tumkur University, and Chairman, Board of Studies, Bangalore City University. He has earlier served as Chairman, Department of Studies in Law, Chairman, Board of Studies, and Chairman, Board of Examination, PG and UG at Bangalore University. He has also been the NSS Coordinator and Nodal Officer, Youth Red Cross, and COVID-19 Cell at Bangalore University. Professor Dr. Sathish Gowda has an illustrious academic background with LLM First Class in Constitutional Law and Business and Trade Law, MPhil in Juridical Science Distinction, MA, PGDH Harem, and PGDM-CJ, all with First Class. He earned his PhD in Constitutional Law 2012 and is presently pursuing LLD at India International University of Legal Education and Research, IIUL ER, Goa. With over 20 years of teaching experience at the undergraduate and postgraduate levels, he has published more than 50 research articles in reputed journals and newspapers and has successfully guided 7 PhD scholars. Sir has represented India and delivered lectures at several prestigious global institutions including Harvard Law School, USA, Georgetown University Law Center, USA, United Nations Organization, New York, International Court of Justice, The Hague, Regent International College, Thailand, among others. He is proud recipient of State Award for Best NSS Coordinator 2021-22 conferred by the Honorable Government of Karnataka and the Young Scientist Social Science Award for the Best Presentation at the First International Congress Conference, Bangkok, Thailand. Sir, we kindly request you to address the gathering and share your valuable insights.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. Respected dignitaries, on and off the dais, today's chief guest, Hon'ble Mr. Justice E.S. Indires sir, Honorable Judge, High Court of Karnataka, and Honorable Administrative Judge, Bangalore South, and Mr. S.S. Mahendra sir, former Principal Government Advocate, High Court of Karnataka, and today's our friend B.M. Hegde, Editor Vakila Vahini, and Chandrakant Patil, Advocate, and very dynamic CEO of this wonderful institution, Shri Kirtan Kumar sir, and young principal of this esteemed institution, Shri Vishwas Gupta Swami, and all the respected faculty members and my dear students. I am really happy to be the part of this wonderful event. And let me congratulate at the outset the organizers for taking pain to organize this wonderful event. I know the difficulties in organizing moot court competition because we are in University Law College, almost we are about to complete 30th All India Moot Court competition, and where bringing everyone together is not an easy task. And when I was talking to principal, he told how many participants are participating in this event. He told 41 team across the country. So we can see the constitution here itself, because constitution represent all types of people with different background. So here also all students from different part of the state can be seen in one row, that is in Soundarya College of Law. And I don't want to take much time because you are eagerly waiting for your announcement. But nevertheless, I wanted to tell something. We always say winning and losing, it's a very different issue. I always say it is immaterial. Whether you win or lose, that is immaterial for us. According to me, whoever participated from yesterday to till now, they won in the moot court. How? In the sense, because coming to moot court competition, many students from different states, they have an opportunity to visit Bangalore, beautiful city. When I was a student of LLB, I participated in one of the moot courts in Trichur, Kerala. More than a winning, going to Kerala, it's a wonderful event, wonderful opportunity for a student. So similarly, not only that, it's just connecting all the students from different parts of the country, networking, creativity, innovative. And more than that, when we were asking questions to all of you, some students, they were committing some mistakes and they were not in a position to say something. And when I was preparing moot problems and all, we used to go to lawyer's office. And I used to contact with senior counsel. We were having discussions. They were telling something, where we were learning something. And we used to meet the experts in the same field. And we never visited library. When we start doing something, preparing moot court, then immediately we always spend time with the library. And so many things we will be learning. We say we lost in the competition. No. You won. One of my teacher used to say, winners will win, losers will learn. Winners will win, losers will learn. Intellect cannot blossom without reading. My principal, Professor Dr. C.A. Gurudat, wonderful teacher, he used to say, Sathish Gowda, read more and more, which reveals your level of ignorance. When I heard this, immediately what comes in my mind, listen more and more, which reveals your level of ignorance also. So, we should be a wonderful listener. I think more than getting prizes and all, winning part is knowing so many international conventions, constitutional provisions, then Nagoya Convention, WIPO, then all this Land Acquisition Act, Biodiversity Act. That is a more than winning point, according to me. And if you go to the college, you will just study only one subject in each period. But in this period, you will be knowing so many subjects. So there is a geography of moot court. You can start traveling anywhere, whichever the point, from which point to another point, you will learn that. And you will develop the capability of thinking in an innovative and different perspectives. And I always make fun. If you want to become a good judge, participate in essay writing. If you want to become a good advocate, participate in a moot court and a debate competition. And when I participated in so many debate competition, but I won in only one debate competition, that too, third prize I got it. But no regret for me, because today I am standing before you all and speaking with confidence. That I learned through this active participation in the debate competition. And as Honorable Justice Sir told, you must read some of the good books written by the great legal luminaries. My father used to say always, read autobiography of great legal luminaries, so that you will come to know in your profession what to do, what not to do. The best example, Courtroom Genius by Nani Palkiwala. Wonderful book. And Neither Rose Nor Thorns by Justice H.R. Khanna. Then, as Sir told, Roses in December, one should read Justice Chagla's Roses, and Before Memory Fades, and so many, Fali Nariman. They have contributed lot. Unfortunately, we are not reading. And today also, I definitely tell you, some of the students who participated in this event, they have prepared their moot problem, everything, going through ChatGPT and other things. But that is not an end. You have to go more than that. So, my concern always, being a student of law, they started telling registrar evaluation, former chairman, that is not. I am permanent student of this wonderful subject. So, and one more, the outcome, whatever you did it now, whether you win in the competition or lost in the competition, that is immaterial for you. My sincere appeal, please start writing an article. That doesn't go waste. Whatever work you have carried out, MC Mehta has done a wonderful job. You should also become like MC Mehta. And I always, there is a statement, law did not emerge from the vacuum. It's a continuous process of evolution, reformation, and recreating the existing system of governance by the eminent scholars like juries, judges, academicians. And there, in that addition, mooters should also come. Mooters also can contribute a lot. Because see, when you get into these subjects and all, you will have a hold and you will learn something out of which. So after going back to the after going back to your respective institution, proudly you say to your principal, sir, I won in the moot court competition, learning so many aspects, meeting good friends, networking, and seeing wonderful, beautiful place like Bangalore and all. So winning, it's a just encouragement, motivation. And one more, I tell my students, you should always follow 5P principles. 5P principles means plan, prepare, practice, present, and produce. Whichever, whether you want to become a judge or whether you want to contest in the, whether you want to participate in the moot court or whatever, even to prepare IAS case, plan, prepare, practice, present, produce. And maintain D4 principles, dignity, decency, decorum, and discipline. They are very much required nowadays. And more than that, in this type of event, you will be knowing so many, the type of, like, I always say that some of the best traits, one should have that communication skill. Communication matters. Language matters. Command over subject matters. And gesture matters. And very importantly, you should be humble while submitting your views. And sometime what happened, we prepare everything. Whether judge, whether he asks the particular point or not, you wanted to vomit everything. No. Whatever, that is a not. Where you have to be there, and because you have studied all legislation, you have studied all international convention, it necessarily doesn't mean that you have to tell everything. You have to have application of mind. So, the best traits, one should have that. Communication, very important in moot court. Then command over language, confidence, determination. These are all very much required. I hope even losers have learned all these things. So there is no question of losers or winners. All are winners only. And I wish you all the very best for your future professional and the personal endeavors. Thanks. I once again thank the organizer for giving me an opportunity to be the part of this wonderful event. Thank you one and all.
Thank you, sir, for those inspiring words. Now comes the most awaited moment of the day, the announcement of the winners of the 3rd All India Moot Court Competition 2025. Throughout the competition, each team displayed exceptional advocacy and intellect. However, as the saying goes, in every competition, some race to the top. We now invite Ms. Pranita Pai, Assistant Professor, Moot Court Coordinator, to announce the winners and request the dignitaries to felicitate the winners.
A very good evening to one and all present here. Before we move on to the most anticipated part of today's proceedings, the announcement of the winners, I would like to take a moment to commend all the participants for their hard work and to thank the honorable judges for their invaluable insights and fair evaluation. Now, without further delay, let us proceed to recognize the outstanding performers of this competition. The prize for Best Mooter goes to Mr. Vasudeva Tilak from Vaikunta Baliga College of Law. I request Honorable Justice Indires to hand over the trophy and Advocate S.S. Mahendra to hand over the certificate. A special thanks to Advocate S.K. Mithun for sponsoring the Best Mooter Award. Next, the prize for Best Memorial goes to Symbiosis Law School, Nagpur. The prize for Best Researcher goes to Rakshita Mahipal from Symbiosis Law School, Pune. The position of runners-up goes to team number 24, Shri Jagadguru Renukacharya College. I request our chief guest, Honorable Justice Indires, to hand over the trophy. And I request our special invitees to hand over the certificates. And I invite CEO sir to hand over the runners-up check. The position of winners goes to team number 25, RV Institute of Legal Studies.
Give them a big round of applause.
Please give them a big round of applause. I once again congratulate all the winners and a big thank you to all the participants for today's competition.
Congratulations to all the winners and the participants for their outstanding performance and for upholding the spirit of mooting. We now move on to the facilitation of a distinguished guest as a token of gratitude and respect. I request Honorable Justice, I request CEO sir to felicitate. I now request the dignitaries to felicitate Mr. S.S. Mahendra, former Principal, Government Advocate, High Court of Karnataka. I now request the dignitaries to felicitate Professor Dr. Sathish Gowda N, Tumkur University. Now, we would like to invite Mr. Kirtan Kumar M, CEO, Soundarya Group of Institution, for the presidential remarks.
Good evening, everyone. Not taking much of your time. Respected Mr. Justice E.S. Indires, sir, Honorable Judge, High Court of Karnataka, Mr. S.S. Mahendra, former Principal Government Advocate, High Court of Karnataka, a special invitee, Dr. Sathish Gowda, Registrar of Evaluation at Tumkur University, dear Vishwas, Principal of Soundarya College of Law, Chief Editor of Vakila Vahini, D.M. Hegde sir, Mr. Chandrakant Patil, dear faculty members and students. I know somehow I didn't feel if the RCB won or India team won, the kind of josh that could have been there. And we still have to celebrate the winners. Please give a biggest round of applause for the winners. Because it takes a lot of effort, a lot of courage, and you made the first bold move to come, because there's so many people in your college, there's so many people, who are there in your institutions, but still you took a bold step. and you came forward and you made this first attempt. I think this itself calls that you have achieved something phenomenal in your life. And today I feel it's a great privilege as we draw the curtains on this remarkable edition of All India Moot Court competition. I feel a deep sense of pride and fulfillment over the past few days. We've not just witnessed arguments and rebuttals, but convictions, clarity, genuine passion of law. And I'm delighted to be part of the valedictory function of the Soundarya College of Law, third All India Moot Court competition. My congratulations, biggest congratulations is to our organizing team. I must congratulate team of our principal, Vishwas, and also the organizing committee members, Pranita Pai, Jitin, Apurva, Riya Hundal, and all the Monisha and all the faculty members who are present here. So big round of applause to them. And also, I think I got phenomenal feedback from all the judges who came, and also some of the faculties. Everybody were expressing that, how come you had so many students volunteering? So the student team, the volunteers, you made a best effort, and this is remarkable. We're all thankful, and also I think it's an excellent opportunity. Please give yourself a round of applause. And also, as Indires sir said, because we are really honored to have Honorable Justice E.S. Indires sir, because we met in the previous instance too. I just thought that day we should invite sir, and it has come to a reality. And sir has worked relentlessly, and has had a remarkable feat in the legal fraternity. And sir has set example for so many judges, advocates, and also students. So we're all grateful, sir. And students are really blessed to have you today. And your words of wisdom have really inspired all of us. And we will definitely, Soundarya College of Law needs your guidance and suggestions for the future, sir. Thank you so much for honoring, for being here today. We're really honored to have your presence, sir. Thank you so much. And also, I thank S.S. Mahendra, sir, for being part of today's event. Sir was expressing that how come we must applaud the patience of students, because we have other courses. If it was other courses, I don't think students would have stayed for so long, sitting down patiently, having this kind of hearing. So I think I think students have that kind of a commitment towards law. I think that's why you'll have that patient hearing. So thank you, sir. Thank you so much for coming to our campus. And also, we do need your guidance and suggestion for our journey at Soundarya College of Law, sir. Thank you so much. And also, Dr. Sathish sir has been a constant, he's been our mentor at Soundarya College of Law. And sir has seen our journey. Sir has seen both struggles and success. So thank you so much for coming, sir. And our faculties need your guidance to, in terms of, research, and also ensure that how we have our, mark in terms of research. So we will take your guidance for the future again, sir. Thank you so much for being part. And our constant support from Vakila Vahini, D.M. Hegde sir, and Chandrakant Patil. So they have been our constant support at Soundarya College of Law. We do thank for your constant support, and they're real well-wishers of Soundarya College of Law. Thank you so much for being part there. And thank you, yes, the real social engineers. So my dear students, as we saw the seriousness of the the course, or the seriousness of your arguments, the seriousness of your research, the memorials, what you prepared, and the preparation. So it's a very serious profession we all are in, and we must do justice for what we are doing. So please have that commitment. So it is the personality that can have the success for the future, regardless of your knowledge. It is the personality, the values that you carry forward, and the kind of ethics that you follow in your profession will really have, because courts have different kinds of emotions. The kind of emotions, because I do go to the courts both to learn and sometimes stand. So understanding the OS numbers, the declaration suit, sometimes hearing out others' cases. So law can give a biggest relief, and it can create keep you in a fix. And also sometimes people have lost running the cases. They've lost their all the valuables that they've had. So it is very important as being in the legal profession to give that justice, to do right things for your clients. So client psychology is also very, very important for you all to understand. So I give this message to understand the client psychology. So with that note, I would like to thank all the participants of various colleges across the country. We thank you, your principal, your management, and all the members for being part of the event. And also Manu Patra has been our knowledge partner, and also ALMT Legal has also been our partner, academic partner in the event. So thank you again. May we meet again, and I'm sure in the college and also in the court in the future. Okay. Thank you all the best. Thank you. Jai Hind, Jai Karnataka.
Thank you, sir. We request the winners to share their experience.
To all the dignitaries on the dais and off the dais, a very good evening. I'm short of words. I had all the excitement till I reached finals, and once I made my submissions, I just lost all the excitements. It's quite inexplicable. However, I'm so grateful that we could make it to the finals and we could get the cup. So I just told to my moot court coordinator in the college that the RCB won the IPL in its 18th edition, which coincidentally happened to be the cumulative addition of that particular day, and also the jersey number of Virat Kohli. And I said, this Soundarya is going to be my 5th moot, and my favorite number is going to be 5. So something parallel happens, and it happened, so thankful. And I thank my teammates, Mr. Likith and Ms. Deepika, without whose support this wouldn't have been possible. And it was an absolutely learning experience, and also a very humbling experience. I think that's about the paradox of knowledge. The more you learn, the more you realize how little you know. So I have just realized that. So at this moment, once again, thanks to all, thanks to the hosting institute, and thanks to my teachers at school, at my School of Law, and to everybody else. Thank you very much.
Thank you. To conclude this remarkable event, we now invite Mr. Vishwas Puttaswamy, Principal, Soundarya College of Law, to deliver the oath of thanks.
Honorable Justice E.S. Indires, Judge, High Court of Karnataka, our esteemed chief guests for the valedictory and final rounds, respected guests, dignitaries, colleagues, and dear friends. Good evening to one and all. It's my proud privilege, on behalf of Soundarya College of Law, to extend our deepest gratitude to everyone who made the 3rd All India Soundarya College of Law Moot Court Competition 2025 a grand and memorable success. First and foremost, I offer our most sincere thanks to the Honorable Justice E.S. Indires for graciously presiding over the finals and valedictory as our chief guest. Sir, your presence has truly elevated the stature of this event. Your words of wisdom have left a lasting impression to our students, reminding us of the nobility, integrity, and discipline that the legal profession demands. We are deeply honored and profoundly grateful to you, sir. Our heartfelt thanks also goes to Mr. S.S. Mahendra, former Principal Government Advocate, for his gracious presence and his continued encouragement to our institution. Sir, your support and kind words have always inspired confidence in our journey, sir. We are equally grateful to Professor Dr. Sathish Gowda N, former Chair in ULC, Registrar Evaluation, Tumpur University, Faculty of Law, Dean, Kannur University, for sharing his valuable insights and lending deep depth to this occasion. Sir, your reflections have added great meaning to our gatherings today. Thank you, sir. A very special note of gratitude to our chairman, Shri Soundarya P. Manjappa, whose constant guidance and vision remains the cornerstone of all our efforts. Sir, on behalf, your belief in our institution pushes us to strive higher each year. So I thank Soundarya P. Manjappa, Chairman of Soundarya Educational Trust, in his absentia. Our heartfelt appreciation to our Managing Director, Sunita Madam, for personally overseeing every arrangement for food and refreshments, and Madam's meticulous attention to detail and thoughtful hospitality ensured a comfort and warmth for every guest and participants. Thank you, Madam. And we're also deeply thankful to our Chief Executive Officer, Mr. Kirtan Kumar M. of Soundarya Group of Institutions, for his unwavering and steady support, his guidance, encouragement, and readiness to facilitate every requirement made this competition possible. So thank you very much, sir. Our sincere thanks to Dr. Vasu, Dean and Principal of Soundarya Institute of Management and Science, for accommodating our Law College event on the 10th and 11th of October. Sirs, your generosity in providing classroom facilities and infrastructure played a major role in success of this national competition. Thank you, sir. And we extend our gratitude to Mr. Gagan, the digital team, for their creative support from concept design to visual content. Your efforts gave this competition a strong and professional identity. To Mr. Sujish, thank you for your outstanding work in photography and videography, capturing every special moment that defines these 2 days. Our appreciation too also goes to Mr. Srinivas for procuring all the essential materials on time, Mr. Ajay for efficiently managing the accounts, Mr. Naveen for his dependable IT support, Mr. Lakshman for his logistics support, Mr. Kaushik for the IT support, Mr. Ramesh for coordinating transport arrangement seamlessly, and we also thank Soundarya Paradise for their excellent accommodation facilities for our guests. And special thanks to Mrs. Nirmala, our dedicated PRO, for her tireless efforts in housekeeping and venue maintenance. Her quiet, constant work ensured the comfort of everyone here. And we also extend a warm appreciation to our academic partner, ALM Liga, solicitors and advocates, and our knowledge partner, Manupatra. Their sponsorship, collaboration, and continued association strengthened the bridge between legal education and professional practice. Our heartfelt thanks to our NCC cadets for presenting a dignified and impressive guard of honor. Your discipline, precision, and spirit added grace and grandeur to the ceremony. A special word of appreciation to Mr. Harish, Dr. Harish, and Mr. Suresh Reddy for their meticulous coordination in organizing the guard of honor. Our sincere thanks to administrative staff, Mr. Devraj, George Terry, and Shivana, and security staff, whose quiet efficiency and reliability ensured that every aspect of this large-scale event ran smoothly and punctually. So now, coming to the most important, the pillars of this competition. So may I now call upon my faculties to come on stage to share the stage for the photograph while I thank you all. So first of all, to all the Moot Court coordinators, Mr. Jitin, please come on to stage. Ms. Pranita Pai, Ms. Riya Handal, Ms. Apurva, your meticulous planning, you please stand. So your meticulous planning, tireless efforts, and flawless executions made every round of this competition a model of efficiency and grace. Your commitment to excellence and your ability to lead the precision have truly set a new benchmark of teamwork and dedication. So may I now call upon my sincere gratitude to Ms. Hridaya. Is here, Hridaya? Yeah, please come. For her dynamic and engaging social media coverage that brought every highlight of this competition to life with creativity and clarity. Our sincere gratitude to Ms. Akshata, is here, yes, for her seamless coordination of food and refreshment and arrangements. To Ms. Pooja for meticulously handling registration and ensuring a smooth experience for every participating team. A special thanks to Ms. Dhamini for diligently overseeing the memorial collection and scoring process. Our appreciation to Ms. Kavita for stepping up to the occasion with unwavering support and initiative whenever needed. To Mr. Pramod for efficiently managing transport and accommodation arrangements. Your timely coordination kept everything running without a hitch. And finally, to Mr. Raghavendra sir for planning and organizing researchers' tests with such clarity and precision. So each of you have played an invaluable role in making this competition a success. Yeah. And Ms. Monisha madam, yes, for the organizing this wonderful valedictory stage. So each of you have planned an invaluable role in making this competition a success. So your teamwork, dedication, and reliability reflects the very best. So we'll share one photograph with all the dignitaries. So now, and also the foot soldiers of today's competition. So may I call the Moot Court student coordinators, Mr. Krishna Das. Please stay. We'll take together with the team. Mr. Krishna Das, Tikshan, Shreya, Vaishnavi, Fires. And the student council members, Mr. Shreyas Nair, Ms. Nishita, Kirtiraj, Kiran, and Mr. Nikhil. You all have been the pillars of this program. Your relentless energy, adaptability, and leadership were evident in every moment. The success of this event stands as a testament to your discipline, teamwork, and love for the institution. You represent the very best of Soundarya College of Law, and we could not be prouder. Please share a photograph with the dignitaries. And once again to everyone, faculty, staff, students, partners, and well-wishers who contributed in ways both seen and unseen, thank you so much. So this event stands as a reflection of our collective efforts, please stay, and our state purpose, and a belief in the power of collaboration. As we conclude this year's Moot Court competition, let us carry forward the same spirit of professionalism, learning, and unity that has defined these 2 inspiring days. Thank you once again. Jai Hind, Jai Bharat, good evening, and safe travels.
Thank you, sir. With that, we formally conclude the valedictory ceremony of the 3rd All India Moot Court Competition 2025. We now request everyone to kindly raise for national anthem.
गणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We request the participants and the winners to stay back. I request all the participants to stay back.